Good afternoon to all of you. Please settle down, all of you. Online students, is it audible? Can you all hear me? Students who are watching live. Okay, students, can you hear me? Online students. Okay. So, how many days are pending for the prelims? Around a month. So, you can just leave out 4 or 5 days in that. So, some of the days will go because we cannot plan everything. So, you'll have to plan, I think, around roughly, you can maximum do is 3 weeks. I think you'll plan for the other subjects, you'll have your own plan, but these 3 days, the way that I have said this 500 question is that even if you listen to these classes, but provided as you already learned whatever have to be done from your part. So, all the questions that I have framed this in such a way that almost all the articles in your constitution will be revised, provided you already had the knowledge, whatever is the gap here and there or whatever you want to revise, we will be revising it through these questions. Okay. So, my idea is at least out of 15 questions, we will be in a position to do 12 questions, but provided that you do not miss out anything on whatever I am going to discuss in the next couple of days, including today, that is 3 days. So, the plan is we will try to discuss 500 questions. First 400 question is completely from most of the articles. There are few areas which of course UPSC does not pay any attention, so those things has been excluded. So, based on the 2025 years of UPSC pattern, but almost all the other 400 questions is completely covering the entire constitution, alright. And the last 100 question that I will discuss is like another one complete paper from the area. So, in this way I have done these 500 questions. So, try to pay attention, okay, and any doubts you are welcome to ask, but I will let you know the time, okay. So, do not interrupt me. So, you can just raise your hand, I will just let you know when you want to ask the doubt. So, we will proceed with this. So, starting from the preamble, we will just go, we will try to cover each and everything. So, that is the way the question. So, few question you may already know, so do not get excited and try to interrupt me in middle, because I am sure that you have also prepared well. But yes, wherever there is a scope for learning, you just keep noting those things, alright. Yes. So, I will just proceed with the question number 1. So, you all got the handout. So, all the 200 questions are there, alright. Okay, so come to the first question, and how you can use this material is whatever you do not know, try to make a note of that in the question paper itself, so that you can just glance it and revise it. It will not take much time if you pay much attention. It will act like a quick revision material for you before going to the examination. If you do well in the next two classes, including this particular class, which I do not think, we may spend around 10 to 12 hours or maybe a little more. If you do it well, again it will take you around say 5 to 6 hours. Probably you can revise the entire polity, alright. So, that is the way that this class will be. Alright, so have a look into the first question. So, consider the following statements regarding the preamble to the Constitution of India. The word socialist, secular and integrity was inserted by the 42nd Constitutional Amendment Act 1976. That is true, because the Constitution, if you see, the preamble has been amended only once, and by which amendment? It was by the 42nd Constitutional Amendment Act, where what the students can make a mistake here is, instead of socialist, secular, sometimes students think it is not integrity, rather it is dignity. But it is not the word dignity, it is the word integrity. Only these 3 words has been added. The preamble is enforceable in a court of law in the same manner as fundamental rights. We clearly know that the preamble is just a non-justiciable part. So, these are all easy areas, but please listen, okay. But of course, in the later areas there are things that you will learn, a lot of things. So, preamble is enforceable in a court of law in the same manner as fundamental right is wrong. Preamble is just not an enforceable part, though the Supreme Court in the 𝐂𝐨𝐧𝐧𝐞𝐜 Bagh case has said that the preamble is an integral part of the constitution, but the purpose of the preamble, even today what it serves is only to interpret the provisions in the constitution. It is not an enforceable, it is not a justiciable part, alright. So, what is the answer here? Which of the statements given above are incorrect? Option B is the right answer, alright. So, come to the next question. With reference to the ideals contained in the preamble, consider the following statements. So, the second thing that you have to remember with regard to the preamble is you should know each and every single word that is given, and in the proper order you should be knowing all those things. So, liberty in the preamble includes liberty of thought, expression, belief, faith and worship. Is it the same order? Yes. So, there is also meaning to that, because thought comes first, then you can do the expression. So, this is part of the conscience of an individual. First, an individual should believe in something, so therefore he can have a deeper faith on something, and once he has got a deeper faith on something, then probably he can put it in the form of a practice. Okay. So, in the form of worship. So, therefore, this is correct. Equality in preamble means equality before law and excludes equality of opportunity. Actually, the concept equality that is given in the preamble is equality of status and of opportunity. So, therefore, it includes the word opportunity. So, therefore, this is wrong. Fraternity aims at ensuring the dignity, assuring the dignity of the individual and the unity and integrity of the nation. Is it true? Yes, the very idea of fraternity is to promote common brotherhood and also to respect the other individual. And respecting another individual includes what is called as the dignity of an individual. So, therefore, yes, this particular statement is true. So, what is the answer in this case? It is only 2. Which of the following is correct? Match list 1 and list 2 regarding the terms used in the preamble. List 1, sovereign is related to what? Sovereign is related to the supreme authority. So, sovereign is related to the supreme authority. Yes, we have got this. Should I read more? Sovereign is related to the supreme authority, that is option 2. Secular is related to, it is related to no official thing. Democratic is related to government is elected, okay, this one, and republic is head of the state. So, what is the option in this case? It is option A. Alright. So, come to the question number 4. Which one of the following best reflects the constitutional position of preamble in India? Is it a source of power to the legislature and executive? The preamble is neither a source either to the legislature or to the executive or even to the judiciary. It does not give any power to anyone, but rather the judiciary can use it to interpret the provisions in the constitution. That is it. It is a limitation upon the powers, that is also not true. It helps in the interpretation of the constitution where the language is ambiguous. This is what exactly was held both in what is called as the 𝐂𝐨𝐬𝐴 Bharati case and the case before that as well. That is in the Berubari Union case, which is a presidential reference. In both the cases, this is a consistent view with regard to the preamble. But the only difference in both these cases is in the Berubari Union case, the Supreme Court said that the preamble is not an integral part of the constitution, whereas in the Berubari Union case, they said it is an integral part of the constitution. Yes, any doubts? Okay, come to question number 5. Consider the following statements regarding the preamble to the Constitution of India. The preamble was so far amended once by the 42nd Constitutional Amendment Act. Is it repeated? The expression unity and integrity of the nation was part of the original preamble adopted in 1949. Is it true? So, what is not part of it? So, the word integrity was not part of it. Originally, it was only the word unity. So, therefore, this is wrong. So, this is true. The preamble declares India to be democratic republic, but not parliamentary democracy. Is it true? Yes, whatever is given in the preamble is, it is only democratic republic, sovereign, socialist, secular, democratic republic. It is not mentioning explicitly as what is called as parliamentary democracy. So, this is true. So, what is the answer in this case? It is asking for incorrect. So, you should be very careful about whether it is correct or incorrect. So, the answer is B only. Now, come to the next part, that is we are going to discuss the part 1 of the constitution, that is union and its territories. So, these are all the some of the things that you should know about the preamble. So, be clear about all those things. Statement 1, Article 1 says that Article 1 says that India, that is Bharat, shall be federation of states. Is it true? No, it is not federation of states, rather it is what? It is union of states. Okay, so therefore this particular statement is wrong. The territory of India includes the territory of the states, the union territories, and such other territory as may be acquired. Is it true? So if you read Article 1 of the Constitution, there are certain information that you should know. Article 1 makes it very clear that India can acquire territory, because it says that the territory of India includes the territory of the states, the territory of the union territories, and such other territory as it may acquire in the future. Although it does not say any particular way as to it can be acquired, it is all done only by internationally accepted ways and norms. But Article 1 makes it very clear, as a sovereign state, India can acquire new territory. But suppose if they want to acquire a new territory, that is done by the internationally accepted ways. But however, the acquired territory to reflect into the Constitution of India, who is having the authority to do that? The Parliament, which can do so under Article 2 of the Constitution. So anyways, so this particular statement is true. So what is the answer? Which of the statements given above are correct? It is B only. With reference to Article 3 of the Constitution, consider the following statements. The Parliament may form new state by separation of a territory from any state. Is it true? So can they take away a territory from any state and form a new state? Yes. Not only that, what else they can do under Article 3? They can merge two states. They can take a part of one state and join with another state. They can divide an existing state. They can change the name of the states. Can a union territory merge with a state? Is it possible under Article 3? Can a union territory be converted into a state? Can a state be converted into a union territory? Yes, anything, whichever is an internal reorganization, everything can be done under Article 3 of the Constitution. But whatever is done under Article 3 of the Constitution, there is a specific procedure which they have to follow, which is given in the Constitution itself, which we will discuss to subsequent question. But tell me that in the procedure we know, but anyways I will discuss that, but I just want to put this question. Anyways, we know whenever a state is to be converted, whenever something is to be done under Article 3 of the Constitution, suppose let us assume a state is to be divided into two states. Does it require the approval of the concerned state legislature? It does not require the approval of the concerned state legislature, but the opinion of the concerned state legislature has to be sought. But what if it is in case of an union territory? Suppose let us assume an union territory is to be converted into a state. What about in that particular case? Does the opinion of the concerned union territory is to be sought? Because it might be possible the union territory does not have a legislative body. But what if an union territory has a legislative body? Then also there is no need to take the opinion of the concerned union territory, legislator of the union territory. This opinion is to be sought only in case of the states. Is that clear? But anyways, come back to the question. The Parliament may form a new state by separation of territory from any state. Is it true? Yes. So this particular statement is true. Parliament may alter the names of existing state. Yes, they do have the power to do that, but in this case also they have to follow the procedure which is given in Article 3 itself. A bill under Article 3 can be introduced in either House of Parliament without the prior recommendation of the President. It does require the prior recommendation of the President. But can it be introduced in either houses with the prior recommendation of the President? Yes, that is not an issue. But once the President gives the recommendation, before giving the recommendation, what the President has to do? He has to refer to the concerned state legislature, seek the opinion of the concerned state legislature within the specified time that the President may specify. The time limit is not given in the Constitution. Is that clear? Alright. But that opinion is not binding upon the President. Alright. What is the answer in this case? What is incorrect? It is only one. Okay. So come to the next question. The views of the state legislature are binding on the Parliament in matters relating to the alteration of the area's boundary, alteration of the area, boundary or name of the state. No, the assertion itself is wrong. It is definitely wrong. So this is not the case. Just now we have seen. Reason under Article 3, the President must refer such bill to the state legislature concerned for expressing its views within a specified period. Is it true? Yes. The reason is true, but assertion is not wrong. So what is the answer in this case? Answer is option C. Come to the next question. Article 1. So what is Article 1? Article 1 is India, that is Bharat. Just now we have seen. Article 2. Admission and establishment of new states, which is always external from the territory of India into India. What is Article 3? Formation of new states and alteration of states, which is an internal reorganization. Article 4. Article 4 is basically providing for the exception. What is the exception that is given under Article 4? Any law that can be made by the Parliament either under Article 2 or under Article 3 is not deemed to be a constitutional amendment under Article 368. Which means basically any law under Article 2 and Article 3 can be done by a simple act of Parliament. So that is a majority that is required is what? Only a simple majority, as long as that it is making changes only to the Schedule 1 and Schedule 4 of the Constitution. Therefore, the exception that is given under Article 4 is not a very broad exception. The exception is only what? As long as the law is amending only Schedule 1 and Schedule 4, it can be done under a simple act of parliament. Suppose if there is an internal reorganization or an addition of new state, let us assume a new territory under Article 2 of the Constitution, if any of the other provisions are to be added apart from Schedule 1 and Schedule 4, can it still be done by a simple act of parliament? No, in that case it requires what? In that requires a constitutional amendment under Article 368. Is that clear? So, for example, when Sikkim was brought in, it required a constitutional amendment under Article 368. It was not done by a simple act of parliament. So, what is the answer in this case? So, the answer is option A. Consider the following statements regarding the constitutional provisions on the union and its territories. Parliament may diminish the area of a state under Article 3. Is it true? Yes. But will this diminishing area of a state under Article 3 also allows the parliament to cede a territory to a foreign state? No, they cannot cede a territory to a foreign state. Ceding a territory to a foreign state always require a constitutional amendment under Article 368. Parliament may alter the name of union territory under Article 3. Yes. A law made under Article 3 also amends fourth schedule in all cases. Think about it. Can you tell me whether the statement is true or false? A law made under Article 3 also amends a fourth schedule in all the cases. All the cases means it's an extreme statement. When an extreme statement means it should be true under all conditions. Then only this particular statement is true. Now tell me what is the statement, whether the statement is true or is it false? Why is it false? What is our Schedule 4 of the Constitution is related to? Allocation of seats to the Rajya Sabha. So therefore, there are certain union territories which may not have any allocation to the Rajya Sabha. So any changes to those union territories will not take any changes in the Schedule 4 of the Constitution. Therefore, in all cases is wrong. In most of the cases it may happen, but not in all the cases, because as of now, how many union territories are having allocation in the Rajya Sabha? There are only 3 union territories. Apart from these 3 union territories, if they make any changes, there is no need to make any changes in the Schedule 4. Of course, any change in any of the states will make a change in the Schedule 4, because states are represented in the in the Rajya Sabha, but not all the union territories. Therefore, this is not always right. So, what is the answer in this case? The answer is option C. Come to the next question. Consider the following statements regarding the citizenship at the commencement of the Constitution. Statement 1, under Article 5, domicile in India alone was sufficient for the citizen at the commencement was sufficient for citizenship at the commencement of the Constitution. Is it true? Domicile alone is not sufficient. Be very clear. Under Article 5, domicile is the major criteria. It is the main criteria, but domicile alone is not sufficient. Although the major criteria is domicile, but along with domicile, they have to satisfy any of the conditions that is given under Article 5. If you can recollect, what are the other conditions that has to be satisfied along with domicile? Domicile plus either of their parents, they were born in the territory of India, or either of their parents were born in the territory of India, or at least they were resident in the territory of India for the period of 5 years before the commencement of the Constitution. So, among these 3 conditions, at least one of the conditions has to be satisfied. So, domicile is the primary criteria, but it is not the only criteria. Therefore, this particular statement is wrong. Is that clear to all of you? So, these are all some minute things probably you will have to keep in your mind. So, please make a note of whatever I am discussing. If you want me little slow, I will try to be little slow. I cannot be too much slow also, because anyways we have to cover 500 questions in couple of days. So, wherever you do not understand, you can ask me, okay. Come to the next statement. Under Article 5, a person having domicile in India could qualify for citizenship if either he was born in India, or either of his parents were born in India, or he had been ordinarily resident in India for at least 5 years immediately preceding the commencement of the Constitution. This is what is the provision of Article 5. Okay. So, domicile is the major criteria, but not the only criteria. Alright. So, this is correct. So, what is the answer in this case? It is option B only. So, there are few areas where I have mentioned the article also, but the idea is not necessarily that you have to remember the article, but just try to go through it before the examination. In case if 1 or 2 question comes, it can help you, but majorly 90 to 99% of the questions will be focusing only in the provisions in the Constitution. Sometimes they may ask some articles. Come to the next question. A person of Indian origin residing outside India could be treated as a citizen at the commencement of the constitution under certain condition. Is it true? Yes. Under can you recollect the relevant article? Although it is not important, if you can. Which article provides for this? Very good. Article 8. In fact, if you see the constitution, Article 5 to Article 8 talks about those people who are citizen at the commencement of the constitution. Okay. Done? Slow, slow, slow. Sometimes out of panic you won't be able to do it. Done? Okay. Please come back. So it is Article 8 actually that allows a person of Indian origin to become an Indian citizen. So any person of Indian origin, all that they have to do is they have to go to the nearest Indian consulate wherever they are, and they have to give their willingness to become an Indian citizen. So they will also be deemed to be an Indian citizen at the commencement. So yes, there is a provision. Assertion is definitely right. Reason Article 8 provides for such persons to be registered as a citizen by the diplomatic or the consular representatives of India in that country where they are residing. Is it true? Is it explaining the assertion? Is it explaining or not explaining? Why it is not explaining? If you say it is not explaining, it is very well explaining. It is very well explaining what is given in the assertion. It is saying that under certain conditions they can become. The reason for that is what? Article 8 allows for such a provision. So assertion is explained by the reason which is there under Article 8. So what is the answer in this case? Both uh, A and or are true, and or is a correct explanation of A. All right. So come to the next question. Match list 1 with list 2. List 1, Article 5 is dealing with what? Citizens at the commencement of the constitution. Article 8 is talking about person of Indian origin. So therefore, if you have to just match, Article 5 is this, Article 8 is about uh, persons, this one. Article 10 is about what? Article 10 is about the power of the parliament. So Article 10 makes it very clear. Try to remember. It is Article 10 says whoever is deemed to be the citizen of India at the commencement of the constitution would continue to be the citizen as long as a parliamentary law provides otherwise. Therefore, two things is there very clear under Article 10. The first thing is the concept of citizenship is not permanent. Can it be altered? Yes, it can be altered by way of a law that is made by the parliament. And the second thing that Article 10 also reveals is that who has authority to do this? The parliament has authority. It cannot be done arbitrarily. It cannot be done by an executive action or something. So that is also quite clear. So this is under Article 10. And then this is continuance of rights of citizenship. So don't confuse between 1 and 4. Let me explain you again very clearly. Article 10 is more about protecting the citizenship, as I already said. So as long as the law is made by the parliament, they continue to be the citizen. So Article 10 is further saying how it can be altered by way of a law. But it is merely stating by way of a law it can be done. But which article is actually giving the power to the parliament to do all those things? It is Article 11. So what is the answer in this case? It is option A. Okay, so based on Article 11, the act that was passed, and even today the act that deals with the provisions relating to citizenship is the Citizenship Act 1955. So what are the grounds on which the citizenship can be acquired? Among the given things, is it citizenship by birth, descent, registration, naturalization, incorporation of territory, and there is also something which is what is called as the provisions related to Assam Accord, which is covering those people who are covered under the Assam Accord. But broadly, these are the 5 categories. Okay, so only the major things UPSC may ask. So try to remember all those things. So what is the answer in this case? It is option D. Consider the following statements regarding the Citizenship Act 1955. Citizenship by registration and citizenship by naturalization are identical in all respects and apply to the same classes of person. Is it true? Then why there are different categories? It does not apply to the same categories of people, of course. There is a different things which is covered, because citizenship by registration is only restricted to certain categories of people. If you remember, can anyone recollect to which categories of people it is there? Citizenship by registration. It largely covers person of Indian origin. It covers a person marrying an Indian citizen, and it also covers a person who are overseas citizenship of having overseas citizenship of India status. Only these categories of people are largely covered. But whereas under naturalization, who is covered for citizenship? Any foreigner, but who is not an illegal migrant. Only exception is by the Citizenship Amendment Act 2019. But otherwise it is only for the foreigners who is not an illegal migrant. So therefore, both the categories does not deal exactly with the same categories of people. Is it clear to all of you? So naturalization is for any foreigner, but who is not an illegal migrant. But registration is only for a certain categories of people, because you will understand which is a easier route to become an Indian citizen between naturalization and registration. Of course, registration, the number of years that they have to stay in India is less compared to that of what is naturalization. Therefore, this particular statement is not the correct thing. The qualification for naturalization are provided in the third schedule of the Citizenship Act. Is it true? Yes, that is factually right. Okay. So, if you look into the Citizenship Act, there is a Schedule 3, and the Schedule 3 provides for certain conditions. And to get the citizenship under naturalization, they have to satisfy these conditions. What are those conditions? If you see, they have to reside in India for a period of 12 years. They should know any of the Indian languages in the Schedule 8 of the Constitution. Their background should be clean, in the sense there should be no criminal cases pending against them, and they should have the right intent to become the Indian citizen. That means they should not have any vested interest. So there are certain conditions which is given in the Schedule 3. They have to fulfill all those things. So this is definitely true. Only the parliament has a power to relax the conditions for naturalization in special cases. Is it true? How many of you think it is true? So this is not correct. So whenever the word only in all the cases, be very careful. If you see under the act does give the power to the government of India. It can be done by an executive order. Okay. So only parliament is not the right thing. Tomorrow the parliament can change the law. Of course, that is power is there. But as far as now the law is concerned, it is given to the executives. Executives can pass orders in the form of delegated legislation, and through that they can relax the conditions for any categories of people. Is it clear? All right. So this is not the right thing. So if the government of India wants to confer citizenship to any person through naturalization, they can relax these conditions which is given in the Schedule 3. And who has got the power to do that? The government of India. That is basically the Ministry of Home Affairs, which is the implementing authority. By an executive order, they can relax the conditions. All right. So what is the answer in this case? It is 2 only. With reference to overseas citizenship of India, when was this overseas citizenship of India status brought in? There are few things probably you should remember as a fact. When it was brought in? Very good. Citizenship Amendment Act 2003. In 2003, this was brought in. But also tell me that this OCI status, is it equivalent to that of dual citizenship? It is not equivalent to dual citizenship, because a person with OCI status can become an Indian citizen, provided he satisfies certain conditions under the law. So it is not dual citizenship. OCI is same as dual citizenship under the Constitution of India. Is it true? No, it is only that they will have certain special rights who are having this OCI, overseas citizenship of India status. The scheme is available to certain persons of Indian origin subject to certain statutory exclusion. Is it true? Yes, there are few categories of people, though they may be a person of Indian origin, understand, still they may not be entitled to become or get what is called as overseas citizenship of India status. For example, the law excludes a person of Indian origin from Pakistan and Bangladesh. But if they want, they can exclude more also. But as of now, they are excluding these two categories. So this is definitely true. A person who is or has been a citizen of Pakistan or Bangladesh is excluded from overseas citizenship of India eligibility under the official scheme. Yes, this is also true. So what is the answer here? Which is incorrect? It is 1 only. Come to the next question. Consider the following statements regarding the Citizenship Amendment Act 2019 and its implementation. The 2024 rules were notified by the central government to operationalize the Amendment Act. Is it true? When the rules were brought in? It was in 2024. Can anyone tell me what this rule pertains to? What is this rule related to? Why there is no need for rules to implement this particular act? Very quickly. Basically, the law allows illegal migrants to become an Indian citizen who have entered from 3 countries: Pakistan, Afghanistan and Bangladesh, and belong to 6 religious communities. Therefore, we will have to identify whether they have entered from these 3 countries, though they are illegal migrants, whether they belong to any of these 6 religious communities. Otherwise, what they will do, anybody can say that they have entered from these countries and they belong to any of these 6 religious communities. Therefore, there has to be a mechanism to verify. That is notified by a government order which came in 2024, which was issued by the Ministry of Home Affairs in the form of a delegated legislation. The amendment related to certain migrants belonging to specified minority communities from Afghanistan, Pakistan and Bangladesh. Is it true? Yes. Under this amendment act, the ordinary naturalization requirement for specified person was reduced from 11 years to 5 years. Is it true? Yes. So this is also true. So which of the statements given above are correct? So what is the answer? The answer is option D. Under the Citizenship Act 1955, the citizenship may be lost. What are the ways by which can be lost? Renunciation, termination and deprivation. So in this, what is voluntary? Renunciation is voluntary on the part of the individual. There is no need for any specific reason for that. But whereas termination is an automatic, which happens automatically by application of law under one condition. What is that condition on which the termination can happen? When an Indian citizen acquires the citizenship of some other country without renouncing the Indian citizenship. So therefore, the law will automatically apply and his citizenship is terminated. Deprivation is again under certain conditions in the law. So if there are certain things, if they violate, if the citizenship was acquired by fraud in the first place, if they are criminalized in some foreign country for a certain number of years, then it may be deprived. Okay. So anyways, these are all the grounds on which the citizenship can be deprived. Come to the next question. Consider the following statements. 1. Article 10 guarantees that the right of citizenship, once recognized under part 2 of the constitution, can never be altered by the parliament. Is it true? It can be altered by the parliament. That is what it says. Apart from a law of the parliament, it cannot be done otherwise. So that power is only to the parliament. Alright. So the next thing, Article 11 empowers the parliament to make laws relating acquisition and termination of citizenship. Is it true? Yes. The Citizenship Act 1955 derives its constitutional basis from Article 11. Yes. So what is the answer in this case? It is option E. Which one of the following statement is correct? Statement 1. Renunciation, termination and deprivation are the modes of losing only OCI status, not Indian citizenship. That is wrong. OCI cardholder enjoys all constitutional rights available to an Indian citizen except voting rights. In fact, OCI does not give them much rights. Only few privileges are there. What are the privileges? Lifelong visa will be there. Some property rights are there. So these kind of privileges, but it is no way equivalent to that of citizenship. Under Citizenship Act, the Indian citizenship may be lost by renunciation, termination or deprivation, whereas OCI, overseas citizenship of India, is a separate statutory status and is not same as the dual citizenship. Is it true? Yes. So this seems to be the most appropriate. A person registered as OCI automatically becomes an Indian citizen under Article 5. That is also wrong. Alright. So these are all related to the citizenship. So just try to note down whatever you do not know in the way that you will understand. So therefore you can go back and revise it. If you have already prepared well, you will be able to retain most of the things, but still I will suggest you to at least go through it once before you go to the examination very quickly, so that you will have a lot of information. So consider the following statements regarding the fundamental right in India. All fundamental rights are available only to the citizens. Is it true? In fact, most of the fundamental rights are available to the aliens as well. Only very few fundamental rights are restricted only to the citizens, like Article 15, 16, 19, 29 and 30. Otherwise, it is available to the aliens as well. So therefore, this particular statement is wrong. Fundamental rights are enforceable by courts. Yes, the important feature of fundamental right is they are enforceable by virtue of Article 32 as well as Article 226 in the Constitution. But anyways, in part 3 it is Article 32 which is there. Fundamental rights are contained in part 3 of the Constitution, alright, which is from Article 12 to Article 35. So what is the answer here? It is statement 213 only. Which of the following best describes an important feature of the fundamental rights in India? They are entirely positive obligations upon the state. In fact, if you see, most of the fundamental rights are only a negative obligation upon the state. It is not a positive obligation. Can anyone tell me what does it mean by negative obligation upon the state? They all try to restrict the powers of the state. But there are few things which are in the form of positive obligation. Can you give me an example of positive obligation as well? So, for example, right to education is a positive obligation. For example, Article 15 Clause 3, though it is not a direct fundamental right, it is an enabling provision which is a positive obligation. What is the obligation under Article 15 Clause 3? For example, make special provisions for the empowerment of women and children. But most of the things are only trying to restrict the authority of the state, but not completely everything is positive. So, this is definitely their entirely positive obligation is not the right thing. They are entirely negative injunction against the private individuals only. In fact, most of the things are only directions or restricting the powers of the state. Only very few things are against a private individual. Therefore, this is also wrong. Can you give me an example of where the fundamental right may also apply against a private individual as a restriction? 17, untouchability is there, okay then? 23, 24, Article 15 Clause 2, if you see no discrimination in certain grounds. So, but not all the things are against a private individual. So, therefore, whenever in all the cases only if such statement comes, if you go by UPSC language, 90% of the time it is always a wrong statement, but there is always exceptions. We do not know in your case it is an exception or they following the general rule, but what you will have to do is probably you will have to be more focused when you are solving such questions. They contain both limitations on the state action and certain affirmative protections for individuals. Is it true? Yes. So, mostly it is a limitation, but there are certain enabling provisions which act as an affirmative action, as I have discussed in case of Article 15 Clause 3, Article 15 Clause 4 or Article 16 Clause 3, Article 16 Clause 4, all those things. They operate only during a proclaimed emergency, no, okay. In fact, during emergency it can be suspended subject to some limitations, of course. Come to the next question. With reference to the fundamental rights under the Constitution of India, consider the following statements. Most fundamental rights are available against a state, but some also operate against private individual. Yes. So, this we already seen. Some overlap may be there here and there. Fundamental rights are absolute and cannot be restricted under any circumstances. In fact, the fundamental right, one of the important feature is they are only qualified in nature. They come with what is called as reasonable restrictions. So, absolute is not the case. A person can directly approach the Supreme Court for the enforcement of fundamental rights. Yes. So, under Article 32, they can directly go. Now, try to understand that the fundamental rights in our country are qualified. That means they can be restricted, but to what extent they can be restricted is given in the Constitution itself. Is that clear to all of you? So, what is incorrect here? It is one only. Okay, tell me the answer for the next question. Article 12 is related to what? It is related to the definition of state. We will also have a question. We will see the what is there in the definition of state, but it is related to definition of state. What is Article 13? Laws inconsistent with the fundamental rights are declared to be invalid, but whatever is the law which is inconsistent with the fundamental right, to what extent do you think that these laws will be declared to be invalid? Here the law under Article 13 has nothing to do with basic structure. A basic structure you should think about only when there is a constitutional amendment. Okay, so here the question that I asked is, suppose let us assume a law XYZ was passed by the parliament where some of the provisions of that law is found to be violation of the fundamental right. My question is, to what extent this law will be declared to be invalid? The entire law will be declared to be invalid? Only to the extent of the inconsistency it will be declared to be invalid. Is it clear to all of you? The entire law will not be struck down, only the extent of inconsistency it will be struck down. That is something that you have to remember. Come to Article 32 is related to what? Direct constitutional remedy to enforce fundamental right. Part 3 is related to fundamental right. So, what is the answer here? Answer is option A. Consider the following statements regarding Article 12. In part 3, the state includes the government and parliament of India. Is it true? So, can anyone recollect what are the things which is covered under the definition of state in Article 12 of the Constitution? So, it includes both the legislature, that is the state legislature as well as the parliament. It includes government of India as well as the government of the states. It includes all the local authorities, and then it also includes any other authority within the territory of India or under the control of government of India. which is quite ambiguous, which is what is explained by the Supreme Court. The Supreme Court has given certain parameters as to whether they will fall within the definition of state or not. The prelims question may not go to that extent, but at least you should know what is given in the constitution, alright. So, what about statement 1? Yes, this is true. It also includes the government and the legislature of each state. It excludes local authorities. No, it does not exclude local authorities. So, what is the answer here? It is 1 and 2 only. Which one of the following best reflects Article 13 of the Constitution? So, what is the most appropriate thing? Any law inconsistent with the fundamental right is wholly void in all circumstances. No. Laws inconsistent with the fundamental rights are void to the extent of such inconsistency. That is true. So, when you are discussing Article 13, you should also know about two doctrines. One is doctrine of eclipse and doctrine of severability. Very quickly, what is this doctrine of severability? Doctrine of severability says that if any post constitutional law, provision of any of the post constitutional law is in violation of any of the fundamental right, to the extent of such inconsistency, the provision will be severed. That means it is struck down from the statute. It no longer continues to be part of the statute. That is basically what is called as doctrine of severability. Sever means it is taken out, it is cut down. But this doctrine is applied only in case of which kind of laws? Post constitutional laws, laws made by the parliament or the state legislature post the commencement of the constitution. There is also something which is called as doctrine of eclipse. What do you understand by doctrine of eclipse? Doctrine of eclipse applies to the pre-constitutional laws. That means those laws which came into existence before the commencement of the constitution. Now, in these cases, even if some of the provisions in the pre-constitutional law is in violation of the constitution, these laws are not complete, these provisions are not completely struck down. A benefit is given to these laws for the reason that these laws were made even before the concept of fundamental rights. So, it is not the mistake to make these laws. What will happen to those provisions? It is only will be eclipsed by the fundamental rights. So, as long as there is a conflict between the fundamental right and those provisions will become dormant. The rationality is that suppose let us assume tomorrow there is a constitutional amendment and this conflict is not there, then automatically those provisions will come into force, alright. So, what is the answer in this case? The answer is option B. Okay, can you tell me the answer for this? Article 14. Fundamental rights, there are two things that you will have to keep. Apart the fundamental rights, the most important area where the question can come from is from the features, because UPSC is not focusing more on the facts. They know that you may know the articles and all those things. Mostly the question may come from features, but apart from that also remember the articles. Sometimes they can ask you questions directly from articles also. And apart from that, you should also know the broader themes, because there are 6 themes of fundamental right, and which fundamental right comes under which theme, that is also important. In this case, what is the answer? Article 14 is related to equality before law and equal protection of law. So, this is what is A. Article 15 is related to prohibition of discrimination on certain grounds. Article 16 is related to public employment, and Article 17 is related to untouchability, alright. So, if you see the scope of protection with regard to equality, the scope is very restricted among Article 14, 15 and 16 is very restricted in case of 16, because 16 is talking about only what? Public employment. Article 15 is little broader, the most broadest is Article 14, alright. So, what is the answer in this case? Answer A. Consider the following statement. Statement 1, all fundamental rights are available to citizens only. Again, it is not the case, because we know most of the fundamental rights are available to aliens as well. Article 19 rights are available only to the citizens. Yes, it is only to the citizens, because the word that is chosen is citizen. Article 14 is available to all persons. Is it true? Yes, because it says no person shall be deprived equality before law or equal protection of law. So, this is true. So, what is the answer in this case? It is 2 and 3 only. With reference to Article 19, consider the following statements. Statement 1, the freedom under Article 19 are absolute. Are they absolute? In fact, lot of reasonable restrictions are given only for this. Okay, so though it is widest in nature, but there are lot of reasonable restrictions also. So, absolute means it is wrong. Reasonable restrictions may be imposed on some freedom in the interest of public order, decency or morality. Is it true? Yes. So this is a ground, especially these things apply in case of what is called as right to freedom of speech and expression. Article 19 clause 2 is one of the reason why the fundamental rights are not absolute. Is it true? What is Article 19 clause 2 talking about? It lays down the list of reasonable restrictions in case of right to freedom of speech and expression. So how many restrictions are there in case of right to freedom of speech and expression? 8 grounds. All the 8 grounds are listed in Article 19 clause 2. Not very important that you should know Article 19 clause 2, but sometimes because it has lot of clauses, because the reasonable, and I am sure that you might be aware of this, that the reasonable restrictions are not same for all the fundamental rights under Article 19. Different fundamental rights are having different restrictions under Article 19, but Article 19 clause 2 is specifically talking about which fundamental right? About the right to freedom of speech and expression, the restriction to right to freedom of speech and expression. So can anyone recollect the 8 grounds? Is there anyone who can tell me without making any mistake that you know all these 8 grounds? Although may not be relevant, very important, but we do not know what may be asked by UPSC, so we should be prepared for everything. Anyone who can recollect and tell? In the same order as it is given in the constitution. Okay, at least the 8th thing anyways. Yes, want to try? Sovereignty and integrity of India, okay. Security of the state, very good. Friendly relations with foreign state, then public order, decency or morality, then defamation, contempt of court, and then the last thing is incitement to an offence. Okay, anyways, if possible you can note it down. Not very important, but at least remember it. At least you should be in a position to eliminate. So therefore you know what are the restrictions in this case, because right to freedom of speech and expression is the most important thing among Article 19. So what is the answer here? Is only 2. Which one of the following or the protection under Article 20, which is talking about protection with respect to conviction for offences? So there are 3 important protection which most of you know. There is protection against ex post facto criminal laws, which means basically 2 things you should know. One is no criminal law can be given a retrospective effect, and a criminal punishment cannot be increased by retrospective amendment. That is not possible. That means you cannot amend and increase a punishment retrospectively. Protection against double jeopardy, that means twice you cannot punish the individual for commission of a single offence at a single point in time. Protection against self incrimination, which means individual cannot be forced to give evidence against themselves, but it also means that they should cooperate. It is not that an absolute protection is given to them. So these are all the things you already know, so I am not going much into this. What is the answer in this case? It is it is option D. But here what you will have to notice, when you say that there can be no ex post facto criminal laws, and in case of no double jeopardy, remember this. When I say no ex post facto criminal legislation, that this protection applies only for a substantive law. This protection does not apply for a procedural laws. So that is very, very important. So what is the difference between a substantive law and a procedural law? Can you give me an example of a substantive law and a procedural law? So when I say no ex post facto criminal legislation, it protects what type of law? It protects that a retrospective punishment cannot be increased by a substantive law, which means when I say substantive law, these are all laws which defines an offence and prescribes the punishment. This is basically what is called as a substantive law. Say for example, the penal code or the renamed version of the law is a substantive law. But even if an individual is to be punished for a particular offence which is given in the substantive law, they have to be arrested, they have to be prosecuted, the trial has to be conducted. So these things are given in which law? These things are given in the procedural law. Therefore, the bail conditions, the number of days they can be kept in jail, these things can be retrospectively changed. What cannot be changed retrospectively is only the substantive law, the final punishment that cannot be changed, or the definition of the punishment cannot be, or definition of the crime cannot be changed. And similarly, protection against double jeopardy, this is also very important. Protection against double jeopardy means strictly what is protected is only the punishment that is given by a court of law. It does not include any of the administrative actions. Is it clear? That cannot be counted as double jeopardy. So please come to the next question. Article 21 protects life and personal liberty in accordance with the due process of law as interpreted by the Supreme Court of India. Is it true? Now, why this word as interpreted by the Supreme Court of India is required? Because even today what is read in the constitution, it is only talking about the procedure established by law, but the Supreme Court said it will have the same meaning as that of what is called as due process of law. Now, can anyone tell me what exactly is the difference between procedure established by law and due process of law? Anyways, we have a question to come, but because we are discussing that, I will discuss it here itself. Which gives the judiciary more scope to review the arbitrary action of the state? Due process of law or procedure established by law? It is only the due process of law, not the procedure established by law. So, can anyone tell me exactly how the scope of the judiciary is widened? Yes, one of you, yes. Brought within the scope of judicial review under which doctrine? Very good, under due process of law. Under procedure established by law, what is within the scope of judicial review? Only the executive actions are within the scope of judicial review. So, therefore, yes, statement 1 is right. Article 21A provides for free and compulsory education to all children between 6 to 14 years. Is it true? Yes. Which was brought in by which amendment, if you can recollect? 86 Constitutional Amendment Act 2002. Many times in the class I said there is one unique speciality about this amendment. What is that? Very good. All the three parts has been amended by this 86 Constitutional Amendment. Which are the parts which has been amended? Part 3, Part 4 and Part 4A. Very good. Article 21A was part of the original constitution. No, it was later only inserted. So, what is the answer in this case? It is option A, 1 and 2 only. Which of the following statement is correct regarding Article 22? It deals only with preventive detention. No, it deals with also punitive detention, arrest and punitive detention as well as preventive detention. That is wrong. It provides safeguard against arrest and detention and also contains separate provisions relating to preventive detention. Is it true? Yes. So, we know that what are the rights in case of arrest and detention? Three rights which is directly given in the constitution. Right to be informed of the grounds of arrest. Second is right to be given a choice to defended by legal practitioner of choice and to be produced before the nearest magistrate within 24 hours. But this is not available in case of two things. What are the things it is not available? One is preventive detention and if an enemy alien is to be arrested. So, it is not available and of course, it provides for certain rights in case of preventive detention. Now, remember these things are not available in case of preventive detention. In case of preventive detention, there is no need to inform the grounds of arrest. Although, if you look into the constitution, it says that normally they should be informed of the grounds of detention, but can the state do away with informing the grounds of detention? Yes, in national public interest, they can do away with that. Okay, so that is also possible, and you know that how long they can be kept in detention. These things are important in this case. So, anyways, what is the answer here? It is option D is the answer. Consider the following statements regarding Article 23 and Article 24. Article 23 prohibits traffic in human being and forced labor. Is it true? So, exactly in the examination, it will confuse what is Article 23 and Article 24. Anyways, both the things you will know, but you will get confused. There is a chance that probably you will get confused whether Article 23 is child labor or it is trafficking. So, Article 23 is about what? It is about trafficking and Article 24 is about what is called as child labor. Anyways, Article 23, here it is true. Article 24 prohibits employment of children below 14 years in factories, mines and other hazardous employment. These protections operate only against the state. So, it is against both state as well as the private individuals, alright. So, this is wrong. So, what is the answer here? It is 1 and 2 only. Okay, come to the next thing which is about the religious rights. So, what is the answer here? Article 25 is related to what? Freedom of profession, practice, propagation of religion. So, the one thing that you have to understand here is Article 25 is a right that is given to the individuals. But whereas on the contrary, Article 26 is not directly conferring the right of the individuals, but on the religious denominations. What is a religious denomination is not defined in the constitution. It is only the Supreme Court which has came out and said as to what is a religious denomination. It should have a group of people with a common faith and they should have a organizational structure, whether it is uh, even if it is an unorganized, let us assume a structure also, they should have some form of organizational structure. And then the last thing is they should have a unique name for them, then it would be considered to be a denomination. So article 26 is related to what? It is manage religious affairs. Article 27 is related to freedom from payment of, freedom from payment of taxes. And then article 28 is freedom from attendance of religious instruction. Alright. So when I say freedom from payment of taxes, what does it mean by freedom from payment of taxes? Which means, first of all, no tax can be imposed in the name of religion. But can the tax collected from other sources, can it be used for the promotion of religion? No, it cannot be used for the promotion of religion. It can be used only for the secular activities surrounding the religion, not for promoting any religion. That is prohibited under article 27. So what do you understand by secular activities surrounding religion? It cannot be directly for religious activities, but for secular activities surrounding the religion, because surrounding a religion, there can be number of practices which is not directly related to the religion itself. Can you give me an example of secular activities surrounding the religion? For example, providing food, shelter to the pilgrims. These are all secular activities surrounding the religion, for which the state money can be used, but the state cannot directly promote the religion. That is not possible. And then of course the last thing is prohibition of any religious instructions or religious worship in educational institution. So broadly we can divide that into three types of educational institution. One is educational institution only owned and maintained by the state, where religious instruction and worship is completely prohibited. Second is educational institutions which are established by an endowment, though managed by the state. So can there be a possibility of religious instructions? Yes, but only on voluntary grounds. It cannot be compelled. All right. And then the third type of educational institution is basically, there are educational institutions, private educational institutions, whether recognized and aided or unaided by the state. So in these cases also the religious instruction is possible, but again on a voluntary basis. Is that clear? So try to remember all those things. So what is the answer in this case? Answer is option A. Consider the following statements. Statement what? Article 29 protects the interest of the minorities only. What is the difference between Article 29 and Article 30? In fact, very good. Article 29 not only protects the interest of the minorities, but any section of citizens, but satisfying certain conditions. What is it? Having a distinct language, script or culture. Any one of these things is sufficient. And what is the way by which they can protect it? Any legitimate means. Of course, the legitimate word is not given in the constitution, but it goes without saying, which is implied that they can do it and protect it by any means. Alright. But on the contrary, Article 39 is only for whom? Only for minorities. And what are the grounds on which the minorities can be identified? It is only on two grounds, religion and language. And what is the right that they have got under Article 30? To establish and thereby administer educational institution. So therefore, the scope of Article 30 is very, very restricted than the scope of Article 29. For the reason Article 29 is for whom? Any section of citizens, whereas Article 30 is for whom? Only for the minorities. Under Article 29, they can protect it by any means, but whereas under Article 30, establish and administer the educational institution. Is that clear? But however, you'll understand that establish and administer educational institution in 2025 beginning, the Supreme Court has categorically said that suppose if an educational institution is established, which was later taken up by the government by an act, does not automatically deprive the minority status, because even though the statutory status is given to any educational institution, what has to be seen whether it is to be considered as a minority education institution or not, they have to again go behind the purpose and the origin behind the establishment of that education institution, which is related to which case, if you can recollect. Very good, Aligarh Muslim University. All right. So what about this particular question? 29 protects the interest of minorities only. No, that is wrong. Article 30 gives minorities right to establish an educational institution of their choice. Yes. Article 29 protects the right of any section of citizens to conserve their distinct language, script or culture. Is it true? Yes. What is the answer here? It is incorrect, one only. Article 32 is itself a fundamental right. Assertion is true. Reason is it guarantees right to move the Supreme Court for the enforcement of the fundamental right. Is it explaining the assertion? Yes. Not explaining. You say it is not explaining. I do not know how to explain that. For me, it is explaining. It is directly explaining it. Okay, so this type of questions just take a moment. It is, see, assertion is you are just putting something as a theory. You just see that you are asserting something. Reason, whether the reason is explaining it or not. Is it explaining? Because how do we know that Article 32 is a fundamental right? Article 32 in itself is a fundamental right because what is basically given under Article 32? It is giving us the right to move to the court to seek justice in case of violation of the fundamental rights. All right. Article 34 may be, or Article 33 may be again very relevant for this year's examination. Anyways, what is common between Article 33 and Article 34? It is allowing the fundamental rights to be restricted. Whereas Article 33 allows the fundamental right to be restricted for certain categories of people, which is of the armed forces and other analogous forces. But who has got the authority to restrict it? Parliament is the only authority. The Parliament has the power to do that. And they may specify under the law to what extent they can restrict the fundamental rights. And what is Article 34? Can anyone tell me what is Article 34? Article 34 has nothing to do with the proclamation of martial law. So, it has nothing to do with martial law in itself. But what is Article 34 related to? Try to understand. See, there is nothing which is given in the constitution as to how the martial law can be imposed. Martial law has never been imposed, in fact, after the commencement of the constitution. If at all they can be done, they can be done by an executive action. But what Article 34 is talking about? It is talking about two things. First, Article 34 allows to restrict the fundamental rights in case a martial law is imposed. Second, it also allows the Parliament, it also gives a power to the Parliament to make a law, and by that law it is trying to protect the officers who are implementing the martial law even if their actions are violative of what is called as fundamental rights. Therefore, only these two things are talked about in Article 34. I am just repeating it again. Article 34 does not talk about proclamation or imposition of martial law, which can be done by an executive action. But in case if a martial law is imposed in a particular state, Article 34 is giving the power to the Parliament to make a law, and by that law to protect the officers implementing the martial law even if their actions are violative of fundamental rights of the others. Is that clear? So, and it also allows them to take away the fundamental rights. Only these two things are allowed under it. But anyways, practically Article 34 has been never used after the commencement of the constitution. And Article 34 is not equivalent to that of national emergency. What is the fundamental difference between national emergency and martial law? Because sometimes I understand that students do have a doubt between these two things as to what is a martial law and what is a national emergency. Now, the crux of it, there can be multiple differences that you can bring in, but what is the crux of the difference? Okay, leadership is with whom when there is a national emergency? Leadership is still with an elected government. When the national emergency is also there, leadership is still with whom? It is only an elected government. It is only the president on the advice of the prime minister who proclaims an emergency. The leadership is still with an elected government, but in a martial law, which is very narrow and very restricted in scope, but there the complete leadership is given to a military authority. So, the laws, the justice, everything is taken care by the military officer. But anyways, you should just know what is the basis. So, martial law is not equivalent to emergency. Anyways, Article 33 empowers a Parliament to modify the application of fundamental rights to amend the to armed forces and certain other forces. Is it true? Yes. This is important because recently an army officer was terminated from service for not performing some of his duties, where he tried to seek protection under Article 25 of the Constitution. But counter to that, it was argued that under Article 33 the rights can be restricted. Okay. So they do not have the same fundamental right as that of an ordinary citizens. Article 34 deals with the restriction of fundamental rights while the martial law is in force. Yes. Article 35 gives exclusive power to the parliament to make laws on certain matters related to part 3. Is it true? Now, if you see in part 3 of the constitution, in part 3 there are different words, languages used in various articles. In certain articles they use the state can do this. In certain articles they can say it can be done by a way of a law. In certain articles they used parliament by a way of a law. So, but the final clarity is given under article 35. So, now try to understand wherever the word state is preferred. We know what is the definition of state under article 12 of the constitution. So, any of those things can do that. That it can be done by a law or it can be done by an executive action also, by an executive order also. But if it is to be done by a way of a law, so who can make the law? Parliament as well as state legislature. But article 35 specifically saying that though the word law may be used, it is specifically whose authority to make law? Parliament by law. So, whatever is given in article 35, it is only the authority of the parliament. Whatever is not given in article 35, but by a way of a law, it can be done under part 3. It can be done by both parliament as well as state legislature. For example, can you give me one provision in part 3 where it can be done by both parliament as well as state legislature? Okay, preventive detention is there. Both can make laws. Agreed. Any other provision apart from that? As an I am talking about an affirmative action, which both can do. Very good. Article 16 class 6, article 15 class 6, specifically by a law. Can anyone tell me, because these things does not warrant a law per se, specifically by a way of a law? Can you give me an example? So, for example, right to education article 21, it is only saying by a way of a law, and article 35 does not restrict it only to the parliament. So, it can be done by the state legislature also. But there are certain things which can be specifically done only by a law made by the parliament. Can you give me an example of what is there in article 16 class 3, not 2, article 16 class 3, which is related to what? Reserving certain seats for the local residents. That is article 16 class 3. Any other provision? Very good. Article 32 class 3. What is article 32 class 3? Although you do not have to remember the exact provision, but at least what is the provision? That presently who can issue writs for the protection of fundamental rights? Supreme Court and the High Courts. But in the future, if the parliament want to make a law, they can make a law, they can give the power to the subordinate courts also to issue writs for the protection of fundamental rights. But who is authority to make such a law? Parliament. And also any of the other things which is considered to be an offence under this act. There are certain things which are considered to be offence, be it untouchability or be it child labour or be it trafficking. For all those things, who can prescribe the punishment? Only parliament by law can prescribe the punishment. So, all those things are given under article 35 of the constitution. Alright. So, just try to remember all those things. So, exclusive power to the parliament. Yes. So, this is true. So, what is the answer here? Article 33 empowers the parliament with regard to the armed forces. Article 34 restriction of fundamental rights or martial law. Article 35 gives exclusive power to the parliament to make laws in certain matters relating to part 3. So, what is the answer? It is all the 3. Which of the following is not correctly matched? What is the answer here? Article 23, protection against arrest and detention. It is article 22, not 23. 23 is related to trafficking. So, not correctly matches. Answer the following statements regarding the enforcement of fundamental right. The Supreme Court can issue writs, orders or directions for the enforcement of fundamental rights. Yes, which they can do. The right to constitutional remedy is itself guaranteed in part 3. Yes, which is article 32. Only the high courts and not the Supreme Court can enforce the fundamental rights through writs. No, both the high courts and the Supreme Courts. The high courts can do it under article 226, whereas the Supreme Court can do it under article 32. Alright. So, which of the statements given above are correct? 1 and 2 only. Answer the following statements about the fundamental rights in India. Some rights in part 3 are available only against the state. Is it true? Yes, they are available only against the state. In fact, most of the fundamental rights are both against the state and private individuals. Some are only, sorry, most are against the state, some are against both and the private individuals. But anyways, the statement is right. Some rights in part 3 also operate against private individuals. Yes. Parliament can, under the constitution itself, make special provisions affecting the application of fundamental rights to the armed forces. Is it true? So which article are they referring to? Article 33. So just now you have seen this. Which of the statements given above are correct? All the three. That is, D is the answer. Answer the following statements regarding Article 14 of the Constitution. It guarantees equality before law and equal protection of law to all persons. Is it true? So equality before law, that everybody shall be treated equally under the law. Equal protection of law is saying that only when people are equally placed, they have to be treated equally. That means it allows for what? It allows for reasonable classification, or it allows for what is called as positive discrimination through reasonable classification. It is available to only the citizen of India. Is it true? No, it is available for all the persons. So, sorry, this is true. Well, this is true. Well, this is wrong. It permits reasonable classification but forbids class legislation. Is it true? So, can anyone tell me what is class legislation? Of course, a statement is true, but do you know the meaning of it? Separate laws for a particular class is class legislation. So that means separate provisions are there made by the state, which is giving reservation only to certain categories of people. So do you call that a class legislation? No, tomorrow the state can make a particular class of people who may get a particular benefit of certain privilege, which may not be available to others. So creating a class of people or a different category of people does not amount to class legislation. What is called as class legislation is that creating a separate category of people on which a privilege is conferred in itself is not a class legislation. When it becomes a class legislation, if a particular category of people is created on whom a privilege is conferred, if that category of people is unreasonable in nature, then it becomes, if it is an arbitrary classification, then it becomes a class legislation. For example, a law or an executive order which is conferring reservation upon the backward classes of people, is it conferring a benefit upon a separate class of people here? But it does not amount to class legislation as long as the benefit is given to the reasonable people, because it's a classification based on intelligible differentia. There is a proper reason behind this classification. Suppose let us assume tomorrow a classification is done where the classification is saying that in a district, for example, I am giving, in a district, only people in certain towns and certain villages should be entitled to government jobs. Others cannot apply for government jobs. Can it be considered to be creating a separate class? It is creating a separate class, but there is no intelligible differentia behind it. Then it becomes what is called as a class legislation. So what is prohibited under Article 14 is not reasonable classification, but what is prohibited? What is prohibited is class legislation, which is basically a classification without any reasonable or without any intelligible differentia in that, or without any proper basis in that. Therefore, this is true. So what is the answer here? It permits reasonable classification but prohibits class legislation. This is true. So what is the answer here? It is option B, 1 and 3 only. Which one of the following best describes Article 16? Equality of opportunity in matters of public employment. Yes. So this is there. Equality of law in all spheres. No, it is limited. Freedom of profession, occupation, Article 19. Equality, protection of life and personal liberty, Article 21. So therefore, that is wrong. Consider the following statement. Statement 1. Article 16 prohibits all forms of reservation in public employment. No, reservation it allows, because as long as it is a reasonable classification, that is allowed, because Article 16 also follows both the principles, equality before law as well as equal protection of laws. If you have seen the entire article, you will understand that Article 16 class 1 and class 2 is based on the principle of what? Equality before law, because no discrimination is the basis. But whereas Article 16 class 3, 4, 4A, 4B, 5 and 6, if you see, they are all based on the principle of equal protection of laws. Reasonable classifications are allowed there. So it does not prohibit. Article 16 prohibit all forms of reservation is wrong. Article 16 is a facet of broader equality code in the constitution. Is it a facet of broader equality? It's not a basis of broader equality, because here the equality is just restricted to public employment. What is broader is Article 15, even more broader is what is Article 14, but it is very restricted. It's relatively restricted, where the equality is only with regard to public employment. Article 16 specifically applies to the matters relating to public employment or employment under the state. Is it true? Yes. So this is not the case. So which of the statements are incorrect? It is option B. Okay, so please give me the answer for the next question, that is question number 44. Help me in connecting it. What is speech and expression? You please tell me the number this side. Assemble peaceful without arms. Very good. Association and unions. Okay. Move freely throughout the territory of India. 3. Very good. So answer is come to the next question. It contains safeguards, it is related to Article 22. It contains safeguards relating to ordinary arrest and detention. Is it true? Yes, of course it is related to ordinary arrest, but if it is used only, then it becomes wrong, because it is also about preventive detention. But anyways, this is true. It also contains special provisions relating to preventive detention. Yes. It abolishes preventive detention in India. No. And with regard to preventive detention, who can make laws in our country? Both the parliament as well as the state legislature, although it is not explicitly given here in Article 22, but you should know what is there in the Schedule 7 of the Constitution. If you see the Schedule 7 of the Constitution, preventive detention is a subject matter both in the union list as well as in the concurrent list. In the union list, it is specifying certain subject matters under preventive detention, where who has got the exclusive authority to make laws? Parliament. And whatever the subject matter which is under preventive detention in the concurrent list, both the parliament as well as the state legislature can make laws. Is it clear to you? And also, no preventive detention can happen in our country except by a law. The law has to authorize for it. Unless until there is a law, the preventive detention cannot happen. But who has authority to, because we know the Constitution itself says, even if the preventive detention happens by way of a law, what is the maximum detention that can be there in case of preventive detention? 3 months, which can be further extended only with approval of the advisory board. But who has got the authority that in certain cases of preventive detention laws, that who has got the authority to make law and exempt that in those cases that the approval of the advisory board is not required? Even without that, they can extend it. It is only the authority of the parliament. Is that clear? And further, the Constitution very clearly says that whatever may be the law, be it the law made by the parliament or be it the law made by the state legislature, that under the preventive detention law, the detention cannot be beyond the period for which, or the maximum detention which is authorized under that particular law. So even if they extend with the help of an advisory board, they can extend it till what point of time? Maximum time that is allowed under the particular law under which the individual is detained. Is it clear to all of you? So what is the answer in this case? It is 1 and 2 only. Come to the next question. Article 29 protects the right of any section of citizens having distinct language, script and culture to conserve the same. Is it true? Yes. Article 30 gives all the citizens right to establish and administer education institution. No, it is only for whom? Minorities. And who are considered to be minorities? Linguistic and religious minorities. Only 2 categories of minorities, but the Constitution does not define who is a minority here. That is, as to how to identify the religious and linguistic minority. Therefore, how to identify this religious and linguistic minority? The Supreme Court has already clarified, in identifying the religious and the linguistic minorities, it is the state that shall be taken as a geographical entity, not the entire territory of India. Alright. And within a state, the Supreme Court has further given a principle, a formula, that any section of people or a language speaking community or a religious practicing community whose population is less than 50% would be considered to be minority. Therefore, for all practical purpose, now see, is it possible that more than one section of people can come under minority in a state? It is very much possible, provided if there is a state where the state itself is having a lot of migrant population, very much possible even all the section of people can fall under that, because as long as they are more than 50% of the population in terms of religion or language, they would still consider to be minority. Article 30 specifically provides the right of minorities to establish and administer education institutions of their choice. Yes. So this is also true. So what is the answer here? It is 1 and 3 only. Which of the following statement is correct regarding Article 32 of the Constitution? It can be used for the enforcement of any legal right, whether fundamental or not. It's not about the legal right. It is itself a fundamental right and provides the right to move the Supreme Court. Yes. So anyways, the answer is option B. Just move further. Consider the following statements regarding the idea of due process of law in relation to Article 21. The expression due process of law is explicitly used in the text of Article 21. No, it is not the case. Article 21 originally uses the expression procedure established by law. Yes. Through judicial interpretation, Article 21 has been expanded so that the procedure must be fair, just and reasonable. Is it true? Yes. So what difference has been made right now? Earlier, under the doctrine of procedure established by law, that the judiciary does not have the scope of seeing whether the procedure laid down in the law is just, fair and reasonable. All that they can do is that they can only see whether the executive has followed the procedure or not. Even if the procedure is not just, not reasonable, is not fair, still if the procedure is followed, there can be no remedy under the doctrine of procedure established by law. But now, not only that the judiciary can look into the executive actions anyway, they can also look into the provisions in the law as well. Okay. So which is having the broader scope? It is due process of law. So what is the answer in this case? It is answer option B. Therefore, to put it in a nutshell, while the doctrine of procedure established by law has given the scope of judicial review only in case of executive actions, whereas the doctrine of due process of law is giving the scope of judicial review for both executive as well as legislative actions. And to what extent they can review all those things, that to see whether the principle of natural justice has been followed, because when you can say something as just, fair and reasonable, only when they follow the principle of natural justice. For example, they go and arrest an individual. While arresting the individual, they are not even giving the reason to him. There is no natural justice in that. They are punishing some individual by a trial, but in the trial the other party is not given the opportunity to explain his case. There is no natural justice. Therefore, to say the procedure is just, fair and reasonable, the procedure, entire procedure has to be inclusive of the principle of what? The principle of natural justice. So what is the answer in this case? So it is not the case. So this is the case. This is also true. So what is the answer? It is answer option B. Which one of the following best explains the writ of habeas corpus? It is issued to command a public authority to perform a duty. No, that is basically what? That is mandamus. 5 writs are there. You can expect one question. Please listen to me carefully. It is not the case. It is used to quash the order of a lower tribunal, or this is what? That is certiorari. It is issued to produce a detained person before the court so that the legality of the detention may be examined. Is it true? Yes. So in this case, what you will have to remember is this, anyways, you will be knowing it. So you should also remember that the principle of locus standi does not apply. That means not necessarily only the affected individuals have to bring it to the notice of the court. It can be brought to the notice of the court even in the form of a public interest litigation. So the principle of locus standi does not apply here. That is very, very important. Come to the next thing. Consider the following statements regarding the writ of mandamus. It means we command. Yes, which means basically the judiciary is commanding the executive or any of the other authorities to perform certain duty which is supposed to be done as per the law. Okay, so this is very important. It is issued to compel a public authority to perform a duty imposed by law. Is it true? Yes. Can a private authority be directed by the court through a mandamus? Is it possible? It is not possible in all the cases, but if is it possible, the answer is yes. provided the private authority falls within the definition of state and they have a legal obligation to perform a duty. Under such a condition, even a private authority may also be directed by a court through mandamus. So, the private authority is not completely excluded, because you also learned under certain circumstances a private authority may also fall within the definition of state, and if they have a duty to perform, then they can be directed. It can be issued against the President of India for the exercise of the constitutional powers. It cannot be issued against the President of India, that is not possible. Okay. So, this is prohibited, because anyways you understand the President of India does not do anything on his own. It is on the aid and advice of the Council of Ministers, and none of his actions can be questioned in a court of law, and he has got that immunity under which article in the Constitution? Very good, under Article 361. So, therefore, a mandamus cannot lie against his orders. So, what is the answer in this case? It is 1 and 2 only. Any questions? So, we have done half of the questions, 50 questions in set 1. Any questions? No questions. Shall I move forward? Okay. So, come to the next part. Which one of the following best describes the directive principles of state policy? They are enforceable by courts in the same manner as that of fundamental rights. No, they are non-justiciable principles meant to guide the state in its governance. Yes. Now, what does it mean by non-justiciable in nature? That means nobody can go to the court to enforce any of the directives. Suppose if some directives, to implement any of the directive, the state has already made a law, and is it now mandatory for the state to implement this law, or they can say that anyways this law is implementing a directive, so therefore it is our only a moral obligation, if we feel we will implement, otherwise we will not implement it. So, when you understand this, when I say directive principles of state policy is non-justiciable in nature, it is only that nobody can force a state to bring in a policy in the first place, bring in a law in the first place. Once a law has been brought in by the state themselves, then there is a legal obligation for them to implement that. Is it clear to all of you? So, for example, the state talks about a food security mission. Let us assume a National Food Security Act. It is talking about adequate means of livelihood to the people and all those things, to protect the health and all those things as the directive. So, let us assume to implement this, they bring in a food security act, then thereupon the state cannot say no, we will not implement this food security because it is only trying to implement what? The directives. Then there is a legal obligation. But what cannot be forced upon the state is what? That the state cannot be forced to bring this law in the first place. Is that clear? And also you should remember, with regard to the directive principles, it is neither a restriction upon the legislative powers or upon the executive powers, because it is non-justiciable in nature in the first place. So, it cannot force to bring any policy in the first place or a law in the first place. But if the state brings such an action, then they have an obligation to fulfill it. Consider the following statements regarding the term state in part 4. Is the term state again used in part 4 of the Constitution? Yes. In which article it talks about state? Very good. Article 36. In fact, Article 36 again did not explain it fully. It only made a reference to Article 12 in the Constitution. Whatever is a state in Article 12, the same is considered to be state under part, that is Article 36. For the purpose of part 4, the term state is having the same meaning as in part 3. Is it true? Yes. Article 36 makes it this explicit. Yes. Therefore, the DPSP apply only to the parliament and not to the state legislature, because whatever is state will be applicable under here also. That means it may be implemented by the state legislature, by the parliament, or by central government, by the state government, local authorities, everything may fall. So, therefore, this is wrong. Which of the statements are correct? 1 and 2 only. Which of the following article directs a state to strive to promote the welfare of the people by securing social order informed by justice? Which one? Article 38. Article 38 is the one which talks about promoting social justice. This Article 38, although the articles are not very important, but try to remember in case if there is a question. At least try to remember the Gandhian principles and also their articles. Therefore, you will in a position to eliminate the things in case. Sometimes UPSC pick these factual based questions also, like 1 or 2 questions in every subject probably they can ask. So probably around 10% of the questions can be purely factual also. So you cannot completely ignore the fact. Although that doesn't mean that you should overemphasize on the remembering the articles and the facts also. Okay, so can you help me with this? What is Article 39A? Article 39A is related to equal justice and free legal aid. What is Article 40? Organization of village panchayats. What is Article 44? Uniform Civil Code. 45? Early childhood care. So what is the answer? So here also remember the amendments. Sometimes UPSC can also ask the amendments. Can anyone tell me how many amendments are related to DPSP? 40? Okay. 44th, 86, 97. Yes. So try to remember which articles they have amended. So sometimes UPSC has asked from these facts as well. There may be few questions on that also, but remember that. Answer the following statements about Article 39. So Article 39 is the one which provides for 6 sub directives under that. It includes provisions for adequate means of livelihood. Yes. It directs a state to ensure ownership and control of material resources so distributed as best to subserve the common good. Yes, which is collectively Article 39B and Article 39C. It prohibits all private ownership of productive resources. No, that is not part of the directives. It does not. Which of the statements given above are correct? It is. Which is the correct one? 1 and 2 only. And also when you go to the examination, do not think that UPSC is always going to follow the same pattern. So sometimes they can give jumbled also, like I have seen. So normally, so like even in 2 statements, they can give 1 only, 2 only, both 1 and 2. Sometimes they can give both 1 and 2, neither 1 or 2, 1, 2. So be very careful about all those things. Okay. So everything that you'll have to read. Okay. Come to the next question. So can you help me with identifying the answer for 56? Which one of the following is not correctly matched among the 4? Is it okay? Correctly matched. What is correctly matched? Article promotion of cooperative societies, 43B is correctly matched. Article 48A is related to what? It is related to protection of environment. So that is wrong. Article 40, anyways, the separation of judiciary is Article 50, and protection and improvement of environment is again Article 48A. So anyways, here what is correct? So in this case, you don't have to remember each and every article, but you should have a way to identify such questions in case if it comes. Okay. What is Article 40 is related to? Village panchayats. There are few things which UPSC has asked again and again. So such articles has been focused. Answer the following statements regarding DPSP. The aim is establishing social and economic democracy. Yes, that is true. There is no legal obligation for the state to implement DPSP, but they are because they are non-justiciable in nature. Is it true? Yes, it's only a moral obligation. They are fundamental in the governance of the country. Yes. So what is the answer? Which is incorrect as none. Which of the following articles direct the state to endeavor to protect with regard to wildlife? What is the answer? 48A. Okay, can you help me with the next question? Consider the following pairs. Which of the given above are correctly matched? Article 46, educational and economic interest of the scheduled caste, scheduled tribe. Yes. So this is correct. Article 47, raising the level of nutrition. Yes, that is also true. Article 50. This is also true. Article 51. Yes. So the answer is option D in this case. Answer the following statements regarding the fundamental duties. They are addressed to the citizens, which is basically means that it is applicable to whom? To the citizens. So that is true. They include respecting the constitution, national anthem, national flag as one of the directive. Yes. They are directly enforceable by writ petition in the same way as fundamental right. Similar to that of DPSP, the fundamental duties are also non-justiciable. The only difference is there it is for the state, here it is for the citizens. Okay, so therefore it is not the right answer. So which of the statements given above are correct? It is 1 and 2 only. Which of the following is a fundamental duty under Article 51A? So what is Article 51A? To what about to vote in every election? There is no such provision. To pay taxes without exception, that is not a fundamental duty which is non-justiciable in nature, but paying duty is a legal obligation. Otherwise there can be proceedings, penalties, fines and all those things. So to develop scientific temper and humanism, yes. So this is definitely there. To participate in the local governance, no, that is not the case. Which of the following are fundamental duties? To safeguard public property, yes. To protect and improve natural environment, to provide opportunities for education to one's child ward between the age of 6 to 14 years, to provide opportunities for education of one child between the age of 6 and 14 years. Is it a fundamental duty? Why so much doubt? You are also confusing me. Hey, this is the last fundamental duty that was added by the 86 Constitutional Amendment Act. For a moment I was also confused. I want to just refer to my key. Anyways, I'll refer it. So you confused me so much. 63 is okay. That is D. This is the last duty that was added. Okay. What has happened in DPSP is they have changed it from 0 to 6 years by the same amendment. But this is definitely true. The answer is option D. Which of the following is not a fundamental duty? Which is not a fundamental duty among this? To secure the citizens a uniform civil code. There is no such duty, it is only a directives. Therefore, the answer is option D. Consider the following statements regarding the fundamental duties. Fundamental duties were added to the constitution by the 42nd Constitutional Amendment Act. Yes. Original constitution contained 10 fundamental duties. There was no fundamental duty in the original constitution. Therefore, it is wrong. The duty relating to providing opportunities for the education of child or ward between 6 to 14 years was added later by the 86 Constitutional Amendment Act in the year 2002. Probably you can make a note of it. So what is the answer here? It is 1 and 3 only. The basic structure doctrine was laid down by the Supreme Court in which case? 𝐂𝐤𝐴 Bharati versus the state of Kerala case. Okay, come to the next question. Consider the following statements. 1. The Parliament may amend the Constitution under Article 368. Is the Parliament has the power to amend the Constitution under Article 368? Yes. Under the basic structure doctrine, the Parliament amending power is unlimited. It is exactly opposite to that. It is the Parliament power is unlimited. Sorry, it is limited. Earlier it was unlimited, which was restricted by the basic structure doctrine. So this is definitely wrong. The doctrine limits the Parliament from destroying the essential constitutional features. And in addition to that, has the Supreme Court defined this basic structure? The Supreme Court has nowhere defined, even it is not mentioned in the constitution. In the words of the Supreme Court in the 𝐂𝐤𝐴 Bharati case, that they said that there are certain features, if at all, if those features are amended, that would destroy the very fabric and the core features of our constitution, which the founding fathers always wanted to be part of the constitution. So such features can never be altered. That is what they have said. But however, it is not defined exactly in the judgment also, nor there is a word in the constitution. The doctrine limits the Parliament from destroying the essential constitutional features. This is true. So what is correct in this? It is 1 and 3 only. Okay. Now, please try to answer this question. If there is a law which is violating the fundamental right, can it be challenged in a court of law? So what is the article that allows the judiciary to review this? Any law which is in violation of fundamental right. Article 13, very good. So if a constitutional amendment takes away fundamental right, can they be challenged under Article 13? Yes or no? Because here also a constitutional amendment is taking away a fundamental right. Can it be challenged or not? Please be very clear, a constitutional amendment taking away a fundamental right cannot be challenged under Article 13, because Article 13 clearly says a constitutional amendment is not a law under Article 13. Article 13 is only saying any law which is in violation of fundamental right can be challenged. But what is not a law under Article 13? Constitutional amendment is not a law under Article 13. Therefore, a constitutional amendment cannot be merely challenged in a court of law on the ground it is violative of fundamental rights. The only ground on which any constitutional amendment can be challenged in a court of law, and what is the ground on which they can be challenged? The only ground on which they can be challenged is on the grounds of violation of the basic structure doctrine. Is it clear to all of you? Therefore, the only limitation upon the amending powers of the parliament is that they shall not take away the basic structure in the constitution. Can a constitutional amendment take away the fundamental rights? Yes. As long as a fundamental right is not part of the basic structure, it can be altered. So, what is the answer in this case? It is 1 and 3 only. Which of the following have been judicially recognized as a part of the basic structure of the constitution? Which of the following has been considered to be part of the basic structure? Rule of law? Yes. Can you recollect the case name? Not very important if you know, probably. In which case it was declared? The Indira Asani case, the Supreme Court has declared. Not very important, but if you want to make a note, you can note. Federalism, part of basic structure? Yes. Federalism is one of the important part of the basic structure. In fact, in multiple cases they have said, one important case is SR Bommai case, in certain other case also they have declared it. So, very confidently he is saying that it is not the case, but anyways it is part of the basic structure. Separation of powers, yes, separation of powers again there is a case which is called as Raj Narayan case, where the Supreme Court has categorically said that separation of powers is part of the basic structure along with the free and fair elections. So, that is again part of the basic structure. Independence of judiciary, yes, 4th judge's case where the Supreme Court has said that it is part of the basic structure. So, what is the answer in this case? All. So, anyways, such type of questions are very rare to come, but even if you are not sure, try to apply your common sense. Such questions has to be answered. Even if it goes wrong, it's okay, but you'll have to develop that ability of taking the risk, because it is easy to identify which may not be part of the basic structure. Only the core features which you think is very important. Do you think federalism is a core feature under the constitution? Although we are not talking about equal division of powers, but does the constitution provides for division of powers? So, it is very, very important feature. So, all these things are very important features. The constitution can be amended, but its core identity cannot be destroyed. Is the assertion correct? So, basically because of the basic structure, that assertion is right. Reason, the basic structure doctrine distinguishes between the amendment of the constitution and abrogation of its essential features. Is it true? Is it explaining the assertion? Is it explaining the assertion? It is very well explaining it. Why there is a lot of confusion? It is explaining it, because when I talk of the core features, when you talk of assertion of the core feature, where this core features is distinguished from the other amendments, it is only the basic structure doctrine. It is explaining it clearly. So, do not get confused in the examination. So, most of the times for such questions, whatever for the first time you think will be mostly right, but if you think that I will think very well and then I will do it later, sometimes it may go wrong. So, do not think too much. All that you will have to do is you will have to trust in whatever preparation you have done over a period of time. If you have done it properly, then the examination in the process, if you do not panic and unnecessarily complicate it, things will be in your favor. Okay. Do not unnecessarily complicate when you go to the examination. So, just trust in the entire process, trust in your hard work, whatever you have done. Of course, those who have done the work, it may not help everyone. So, if you have done the work, yes, it will be in your favor. Okay. Okay. So, come to the next question. Which one of the following is most accurate regarding the basic structure doctrine? It means no part of the constitution can ever be amended. No. It applies only to the fundamental rights. It was created by parliament through a constitutional amendment. It is a judicial doctrine that limits the amending powers of the parliament by preserving the constitution essential features. Yes. Come to the next area. In the constitutional thought, liberty is best understood as complete absence of all legal restraints. Complete absence would lead to what is called as freedom. So, we are not talking about freedom here. Freedom enjoyed within the framework of law that protects the rights of all. So basically, to put it in a very simple way, what is liberty? Liberty is something of freedom, but which is more regulated by what is called as law, which comes with certain restrictions. All right. So the appropriate answer is what? B. So therefore, what is the relationship between, this was also once asked to be UPSC, what is the relationship between law and liberty? When there is no law, there is no liberty, because when there is no law, it is up to an individual to do whatever they want to do, then therefore one can take away the rights of others. Therefore, if there is no law, there is no liberty. Laws are brought in a civilized society to protect the liberty of the individuals. All right. The idea of rule of law primarily means, what is the most appropriate with regard to the idea of rule of law? Supremacy of law over arbitrary power. So, rule of law, to put it very simply, that the law is above everyone. Everybody is under the law. Okay. Consider the following statements regarding democracy in the Indian constitutional context. Democracy in India is limited only to periodic elections. Periodic elections is just only one aspect of democracy. Periodic election alone would not make democracy, because let us suppose, let us assume there is a periodic election, but there is only one person or one party can conduct the election, others are not allowed. That means there is basically no free and fair election. It will not amount to what is called as democracy. So, that alone will not qualify as democracy. The preamble declares India to be a democratic republic. Is it true? Yes, that expression is there. It is not talking about the other expression. So, to that expression, it is true. Democratic government is a constitutional thought, implies accountability and participation under constitutional limits. So, basically it is saying that it is a limited government, all right, which is also accountable to the people. So, this is true. So, what is the correct answer in this case? It is option 2 and 3 only. Which one of the following best captures the meaning of constitutionalism? So, what is the answer? So, limited government under a higher legal order in which the power is distributed, controlled and made more accountable. Basically, it is limited and there are systems of accountability, all right. So, the answer is option D. So, such a type of question you can expect to one question definitely likely to come. There can be more than one questions also, but as we will proceed, I will try to bring here and there a lot of questions like that. Which one of the following statement best reflects Indian secularism? Which reflects the best Indian secularism? The state must establish one official religion? No. The state is completely anti-religious? No. Constitution bars all religious freedom? No. The state has no official religion and respects the freedom of conscience of the individuals, and while maintaining principled distance and equality among all the religions. All right. So, basically the state has to maintain equal distance from all the religion. Which one of the following is the qualification for that? Now, we are almost done with the first part, that is right from what are the things we have covered. Preamble, then we have done the union and its territories, fundamental rights, some of the basics, features, the constitutional provisions. Alright, so whatever you know, okay, today when you go home, it won't take much time, just go through it very quickly once. Therefore, whatever you have added newly, that will be in your mind, okay. Now, we are moving to the next part, that is the executive part. So, where I will complete all the executives through the questions only. So, basically all these questions moving forward, I have picked up from every article in the constitution. And UPSC, trust me, UPSC and those who are preparing questions in UPSC, they may not even read Lakshmikant. So, they are not going to pick questions from Lakshmikant. I am repeatedly saying this, it is not that you should not read Lakshmikant, but think like UPSC, think like who is going to set the question paper, because they are not going to read that particular book. But it appears that all the questions are coming from Lakshmikant. It is because of the fact the author is following UPSC. UPSC is not following. UPSC is not following the author. So every year they keep updating the questions that is asked. So then later you come and read. For a fresher or someone who is doing the book, it appears that okay, if I read this book, I can answer all the things. But rather they will pick questions only from the constitution, from the articles. So once we cover all the articles, so most likely, so it is not 100% of the question, sometimes it is also possible, okay. But at least yes, we can get 12 questions out of 15 questions, means the job is done for that particular subject. Whatever you do is in addition, extra, okay. So come to the next thing, which one of the following is a qualification for elections as which one of the following is a qualification for the election of the President of India? So he must be a member of either house of the parliament. No, that is not the case. He must have completed 30 years of age. In fact, he has completed 35 years of age as per the constitutional requirement. He should be qualified for election to as a member of House of People. Yes, that means basically he should have all the qualifications as someone who wanted to contest election to the Lok Sabha, which is again given in the constitution. Okay. So he must be a serving judge of the Supreme Court. No, that is not the case. Which one of the following disqualifies a person from being elected as the President of India? Holding an office of profit under the government of India or any of the states subject to constitutional exception. Will it disqualify? So that means basically holding an office of profit will disqualify. Is the term office of profit defined in the constitution? It is not defined in the constitution. So it is only the Supreme Court which has given. So what is this office of profit as per the Supreme Court? Any idea? It has told in number of cases, but one important definition that the Supreme Court has given with regard to office of profit is any office either under the central, state or any of the local authority by way of which profit is receivable. It is not mandatory that the profit has to be received. Even if the profit is receivable, then it is an office of profit. So basically, to put it in a layman term, that means anyone who wanted to contest election to the office of the president, they should not hold on to any government office. By holding on the government office, they cannot contest election. So can they resign and can they contest election? Yes, that they can do. That is not an issue. Otherwise, they would be disqualified to contest the election. But there are few exceptions to this. Constitutionally, few exceptions are there. What are the exceptions? A sitting president, a sitting vice president, then sitting governors, very good, serving governors, then ministers, both at the union level as well as the state level. They don't have to resign from their job. Even without resigning, they can contest, but for others, they have to give up their job. Is that clear? What about a member of parliament? Can a member of parliament contest election to the office of the president? Yes or no? Yes. Sure. A member of parliament can contest election. He doesn't have to resign from being a member of parliament because a member of parliament is not an office of profit. Because I said that any office either under the center, state or the local authorities which is part of the executive branch. A member of parliament, though he may draw a salary and other allowances, but he is not part of the executive branch, but rather he is part of which branch? Legislative branch. But as per the conditions of the president office, a member of parliament who gets elected as the president, he or she ceases to be a member of parliament or a member of state legislature. That means there is no restriction for a member of parliament to contest election to the office of the president. There is no need to resign, but the moment they get elected, they cease to be a member of parliament or a member of state legislature. So what is the answer in this case? It is option A. Consider the following statements regarding the term office of president. The president continues to hold office even after the expiry of the term until the successor enters upon the office. Yes, this is true. The president may resign by writing, by addressing his resignation to the vice president. Yes. The president may be removed only by the Supreme Court. No. So who is authority to remove the president of India? Parliament is the only authority, and the president can be removed only through an impeachment process, and the president can be impeached only for the grounds of violation of the constitution. And what is violation of the constitution is nowhere defined. It is for the house to be satisfied that the president has violated the constitution. Alright, so the president can be removed only by the Supreme Court is wrong. So what is the answer in this case? It is 1 and 2 only. The president may resign by writing under his hand, addressed to whom? To the vice president. So constitutionally it is to the vice president. Which of the following statement is correct regarding the re-election of the president of India? The president is eligible for re-election only once. The president is not eligible for re-election. The president is eligible for re-election without any constitutional limits. So there is no constitutional limit as to how many times one can contest election. So it is only certain convention that is followed. Constitutionally, there is no restriction. All right. Even there is no strict convention that has been followed. The only president who has been elected twice is Dr. Rajendra Prasad. After that, no person has been elected for the second time. But although constitutionally that restriction is not there. Which of the following are included in the electoral college of the election of the president? Elected members of both the houses of the parliament, nominated members of both the houses. The nominated members are not part of the electoral college. Elected members of legislative assemblies of the states, it is only the elected members. But anyways, right now we don't have to worry, because right now presently in the Lok Sabha there can be only elected members. Similarly, in the legislative assemblies also there can be only elected members, because the provision for nominated members in the Lok Sabha and also in the legislative assembly has been done away with. By which amendment it has been done away with? By 104th Constitutional Amendment Act. So earlier, who can be nominated in these bodies? The Anglo-Indians, 2 Anglo-Indian in the Lok Sabha and 1 Anglo-Indian in the legislative assembly by the president and the governor respectively, but that has been now done away with. So anyways, presently only the elected members. Elected members of legislative assemblies of the state, yes. Elected members of legislative assemblies of union territories of Delhi and Puducherry, is it true? Yes, that is also true, but what about the elected members in the legislative assembly of Jammu and Kashmir? Are they part of the electoral college? See, when the last election happened, the Jammu and Kashmir was not having a legislative body, but the next legislative elections may happen in 27, 28, whatever the case. So then there may be a legislative assembly which is there in Jammu and Kashmir. Will they be part of the electoral college? Will they be part of the electoral college or not? They will not be part of the electoral college unless and until 2 things happens. Automatically they may not be part of the electoral college, because even in case of Delhi and Puducherry, it was specifically added as a part of the electoral college only by the 70th Constitutional Amendment Act. So it is not saying that all the legislative assemblies of union territories. Therefore, 2 things has to happen. Either way, any of these things, unless and until these happens, the legislative assembly members of Puducherry may not be part of the electoral college even in the next presidential election. So what is the way by which they can become the part of electoral college? Either Jammu and Kashmir is conferred as status of a state, which can be done under Article 3, or what is the alternative? Constitutional amendment, they include the legislative assembly of Jammu and Kashmir. So unless and until either of these things happens, the legislative assembly members, though elected in case of Jammu and Kashmir, may not be part of the electoral college. So therefore, anyways, for your prelims examination 2026, you don't have to worry, they are not part of the electoral college. Whatever may happen in the future is a different thing, but right now you can go with a clear mind that they are not part of the electoral college. So what is, this is also true. So what is the answer? Is 1, 3 and 4. Consider the following statements regarding the manner of election of the President of India. The election is held in accordance with the system of proportional representation by means of single transfer vote. Yes. The voting is by secret ballot. Yes. The election is by direct election. No, it is by indirect election. It is not direct election. And also, what about the cross voting in the presidential election? Will it attract the anti-defection law, disqualification under anti-defection law? Why? Because anyways it's a secret ballot, nobody will else know as to whom they have voted. Only by the outcome they can come to some conclusion, probably there is some cross voting, but it does not attract the anti-defection law. All right. So what is the answer in this case? It is 1 and 2 only. Which one of the following best describes the constitutional principles behind Article 55 on the president election, which talks about the election of the president? Equality between the nominated and the elected legislators. In fact, there is nominated members are not part of it, so you can directly ignore this. Uniformity in scale of representation of different states and parity between states and the union. Is it true? Yes. In fact, the very principle, if you see, the value of vote of MLAs in different state is not the same. The value of vote of MLAs in different state is different for the reason they wanted to ensure some kind of parity, if not absolute parity. On the relative scale, they wanted to provide some parity. not only between different states, but also to ensure the federal principle of our constitution. They wanted to ensure parity between the states put together on one side and the union on the other side. That is why you will see, if you sum up the value of all the MLAs of all the 28 states and the union territories, add up the value of all the MLAs, and if you add the value of all the MPs and put together, the values are almost the same, alright, approximately it is the same, alright. So, that is what the principle that they have followed. In that way they have used the formulas and all those things. So, this is definitely true. A vacancy in the office of the president is caused by expiry of term shall be filled. A vacancy in the office of the president caused by the expiry of the term shall be filled. What is the answer? Shall be filled even before the expiry of the term, because if you see the constitution very clearly, there are 5 ways by which a vacancy can arise. Vacancy can arise because of the reasons of expiry of the term, by the reasons of death, resignation, removal, or otherwise, which is where the Supreme Court can declare the election to be invalid and all those things. Except in case of expiry of the term, in all other cases the vacancy has to be filled within how much time? Within a period of 6 months. It is said as soon as possible, but anytime it cannot be more than a period of 6 months maximum. But in case the vacancy is going to arise because of the expiry of the term, even before the expiry of the incumbent president, the new president has to be elected, alright. So, if the vacancy is because of the expiry of the term, in this case the vice president can never act as the president of India, because anyways already the president is elected. But I said in one case, sometimes the new president may not be, if you have attended my previous classes, that for those students, that sometimes the new president elect may not be able to assume the office. So, in that time who will act as a president? The outgoing president continues to be the president of India, not the vice president, alright. So, anyways, what is the answer in this case? Before the expiry of the term. If a vacancy arises in the office of the president because of the reasons of death, resignation, removal, or otherwise, the election is to fill the vacancy should be held within a period of 6 months. Till the time who will act as a president? The vice president. Which one of the following is correct regarding the removal of the president? So, we have seen that the president can be removed. Who is authority to remove the president? In fact, impeach the president is the parliament. And what is the ground on which he can be impeached? Violation of the constitution. But the procedure laid down in the constitution says that whenever such a proposal is introduced in the parliament, the president has to be given a prior notice of 14 days, and then the proposal can be introduced in either houses. In whichever house it is introduced, it has to be passed with a special majority. And what is a special majority? Not less than 2/3 of the total membership of the house. Only one thing, that is not less than 2/3 of the total membership passed on to the next house. The next house, the president has the right to defend himself. After that, the motion will be put to vote. The second house also, it has to be passed with the same special majority, that is not less than 2/3 of the total membership of the house. So, what is the answer here? He may be removed by impeachment for the violation of the constitution. And also remember, what is violation of the constitution is nowhere defined in the constitution. So, therefore, who is to be convinced that the president has violated the constitution? Both the houses with the majority, they should be convinced. But can you give me an example of what amounts to violation of the constitution? When it can be seen as violation of the constitution? If he is not acting on the hidden advice, if he is starting to act on his own advice, his or her on own advice without following the advice on their own, then it is a violation of the constitution. The president is merely a nominal executive, alright. But having said that, it is not easy to achieve this majority, because to achieve this majority for a constitutional amendment, what is the majority that is required? Special majority, but 2/3 of the members present and voting plus absolute majority. So, that even that majority recently the government was not able to achieve when they are trying to changes in the delimitation. But to remove the president, you see that without the cooperation of the opposition and all the parties, in fact, that cannot be done. Therefore, it is very important, as I have already said that. So, that is why the government will be very careful in choosing the president, because no government can afford to introduce an impeachment motion against the president, because if the president starts to act on his own, though there is a provision to remove, you cannot remove the president. Therefore, it is better to bring someone who will not do this in the first place. That is why the government will be very careful in electing the president of India. Answer the following statements regarding the impeachment of the president. The charge may be preferred by either house of the parliament. Yes. A 14-day notice in writing is required. Yes. A resolution to prepare the charge must be passed by a majority of total membership of the house and by not less than 2/3 of the members present and voting. The majority is wrong. Basically, they are giving the majority for a constitutional amendment. That is not the case. It is a majority of not less than 2/3 of the total membership of the house. So, what is correct? It is 1 and 2 only. Which of the following statement is correct regarding the exercise of the executive power of the president? Statement, he must personally exercise all executive powers. So, no. The power, it may be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Yes. You see article 53 of the constitution, this is what it is said. He can exercise it directly or through the officers subordinate to him. Okay. So, in both the ways he can exercise it. Under article 74, there shall be a council of ministers with the prime minister at the head to what? Aid and advise the president. Is that advice binding upon the president? Yes. But if you see, prior to the 42nd Constitutional Amendment Act 1976, there was no clarity on this. It is only the 42nd Constitutional Amendment Act which said explicitly that the advice is binding by introducing the word that who shall act in accordance with such advice. Before that, it was largely based on the parliamentary principles that the presidents were bound by the aid and advice. But there were instances where the president did not act on the aid and advice. Therefore, this matter has gone to the courts as well. So, the courts have given direction that the aid and advice is binding. But after 1976, after the 42nd Constitutional Amendment Act, now it is very clear that the president shall act on the aid and advice of the Council of Ministers. But you should also remember that that does not mean that the president should always act on the aid and advice of the Council of Ministers, because you should also understand what is provided for in the 44th Constitutional Amendment Act 1978. What was provided for? That the president can send any advice for reconsideration once. It is not equivalent to his power to assent the bills. His power to assent the bills separately comes from a different article, that is article 111. But here in this case, any advice, maybe giving, passing, promulgating an ordinance, appointing certain authorities, in all these cases, whatever is the advice that is given to the president, can the president send such advice once for reconsideration? Yes, by the 44th Constitutional Amendment Act. Anyways, for this question, what is the answer? It is option B. Okay, we have done that already. Okay, this is also done. So, here also it is option B. Come to the next question. Which of the following is relating to parliament or exercised by the president under article 85? So, basically under article 85, the president can summon, prorogue and dissolve the houses. Dissolve the house basically. But all these powers, try to understand, not the discretionary power of the president, only on the aid and advice. Summoning the sessions of each house of the parliament, can he summon? Yes, but strictly only on the aid and advice of the Council of Ministers. The only thing that the president has to keep in mind is that there shall not be a lapse of more than 6 months between two consecutive sessions. There is no fixed number of session given under the constitution. There is no duration that has been given for any session. So, all these things are based on the aid and advice. The only thing is that there shall not be a lapse of more than how much time? 6 months between two consecutive sessions. Proroguing either houses, proroguing means terminating a session. That is basically, so who is authority to terminate a session? Only the president. Who is authority to summon a session? Only the president. And also there is no fixed number of days where the house has to be in session. None of these things are given in the constitution. Alright. So, proroguing, terminating, both are the authority of the president, but there is also something which is called as adjournment. Adjournment and adjournment sine die. In both the cases, it is done by the respective presiding officer. The only difference is adjournment is a temporary break which is definite in nature, whereas adjournment sine die is also a break but which is indefinite in nature. Alright. Dissolving the house of people, yes. So this was also largely done on the aid and advice of the Council of Ministers, but in one case, suppose let us assume the 5-year term is over from the first sitting, then the president can do anyways, because then thereafter he has to dissolve the house. But is there a possibility of premature dissolution? Yes. If there is a premature dissolution which is not on grounds of no confidence motion, if there is a no confidence motion, the president can anyways dissolve. But if it is not on the grounds of no confidence motion, but the ministers themselves wanted for a premature dissolution, then it can be done only on the aid and advice of the Council of Ministers. Alright, so what is the answer in this case? It is option D. Which one of the following correctly states the president power regarding ordinary bills presented to him? So which is the power of the president comes from article 111 of the constitution. Whenever a bill is presented, he must give the assent immediately. That is not the case. In fact, there is no time limit for the president to give the assent. He may declare that he withholds the assent or return the bill for reconsideration, return the bill if it is not a money bill, or assent the bill. Basically, he has got three options. He can give the assent to the bill, he can withhold the assent to the bill, or he can send it for reconsideration. Where he can send it for reconsideration only if it is not what type of bill? It is not a money bill. Alright. Can he withhold a money bill? Yes, he can withhold the money bill. Basically, withholding means what? What does it mean by? Withholding the bill means that he is rejecting the bill. Withholding means he is rejecting the bill. That is basically what is called as withholding the assent to the bill. What is sending it for reconsideration? Reconsideration means he is on making some note with or without a note. He is not happy with some of the provisions, therefore he is sending it for reconsideration. But what is sitting on the bill? Somebody told me sitting on the bill means that he is exercising his pocket veto. So basically he is not sitting on the bill, which only means that he is either rejecting the bill nor he is sending it for reconsideration. He does not take any action on the bill. That is basically what is the pocket veto. But packet veto is much implicit because there is no time limit for him to act. We also say that he exercises. But if you read article 111 of the constitution, only three things are given. He can give the assent, withhold the assent, where he can reject it, but he can reject it, you know, that because he has to act on the aid and advice of the Council of Ministers, only under certain conditions he can withhold. It is not that always he can do that. And similarly, he can send it for reconsideration. That is his discretion, provided the bill is what type of bill? Is not a money bill, and also it is not a constitutional amendment bill, because in case of a constitutional amendment bill also only one option. What is option? That he has to give the assent to the bill. Clear? Consider the following statements regarding ordinance making power of the president. Statement 1. The president may promulgate an ordinance only when both the houses of the parliament are not in session. Is it true? Either of the houses, not necessarily both the houses. So this is wrong. Okay. So this makes us, so such type of things where students may make mistakes, be careful about it. Okay. Second thing is an ordinance has the same force and effect as that of an act of parliament. Yes, it has the same force as that of a law that is made by the parliament. An ordinance must be laid before both the houses of parliament and ceases to operate at the expiration of 6 weeks from the reassembly of parliament unless approved earlier. Is it true? Yes. So whenever the parliament comes to session, both the houses, and then within how much time it has to be approved? 6 weeks. All that is given in the constitution is only it has to be approved within a period of 6 weeks. Nothing which is given in the constitution as 6 months and 6 weeks. That is not the right interpretation. 6 weeks from the time both the houses comes into session, otherwise it is automatically lapse. So this is true. So what is the answer in this case? It is 2 and 3 only. Under article 72, the president pardoning powers extend to cases where the punishment or sentence is by court martial. Is it true? Is the court martial is the power of the president? Of course it is power of the president. With regard to court martial, who is the only authority? Only the president, where the punishment is by military laws given by a military court or a tribunal. Cases involving offences against laws relating to matters to which executive power of the union extends. Is it true? Yes. In this case also the president will have full authority. All death sentences. Yes. In case of death sentence, it does not matter whether it is a law based on the parliament or the state legislature, whether it is the executive authority of the union or the state, anyways who will have the power, the president will have the power, alright. So, in death cases you will have the power, that is capital punishment. In case of what is called as court martial, you will have it, except for death punishment and except for court martial. In all other cases the president can exercise a power only provided where the executive authority of the union extends. Is that clear? On the contrary, if we compare that to governor, anyways I will do the governor thing again, I do not want to take too much in today's class itself, but if anyone can bring the difference for the governor in these things, what the governor exercise. For other students, if you are not remembering it, no issues, anyways I will discuss it. Definitely not court martial. With regard to death sentence, does he exercise anything? Can the governor pardon a capital punishment? He cannot. Can he commute a capital punishment? Yes, but provided what? Provided the punishment is based on the executive authority of the state. Is that clear? And in all other cases, wherever the executive authority of the state extends. Alright. So, what is the answer here? So, in all the three cases, the answer is option D. Anyways, don't worry about the governor. Anyways, I will do the governor. Which of the following statement is most accurate regarding the president pardoning powers? So, what is the right answer? It includes power to pardon, reprieve, respite, remission and commutation in the constitutionally specified classes of cases. That is very important, not in all the cases. What are the constitutionally specified classes of cases? Court martial, death sentence, and in all other cases where the executive authority of the union extends. What is Article 77 related to? Very important article, that is why I am asking the article. What is Article 77 related to? It is related to the transaction of business rules. Who can make the transaction of business rules for the union government? It is the president who has got the authority to make the transaction of business rules. Alright. So, all the executive actions, I will give a break after completing 100 questions. Some students are asking break because we have to do 500 questions, at least 100 questions will do. All the executive action of the government of India shall be expressed to be taken in the name of the president. Is it true? Yes. Orders and other instruments made in the name of the president must be authenticated in the manner specified in the rules. The orders and other instruments made in the name of the president must be authenticated in the manner specified in the rules. So, under Article 77 of the Constitution, who is supposed to make the rules with regard to transaction of business rules? President. So, he will specify as to what should be done. So, it is also true, orders and other instruments, which means under Article 77 of the Constitution, the president will make organization, authorities who are supposed to authenticate various files. So, it has to be done in accordance with what is specified under Article 77. So, this is definitely true, specified in the rules. The president make rules for more convenient transaction of business of the government of India and the allocation of business. So, this is a broader set. So, within that what he will do is, say for example, within a ministry, in a ministry who will occupy the highest position, excluding the ministers, then you have a secretary, then you have an additional secretary. For what is authority of the secretary, what is authority of additional secretary, who will prescribe all those things? The president under Article 77, or the president can delegate this authority to some others also under Article 77 of the Constitution. According to that, all the instruments has to be authenticated. Alright. So, all the three things are directly given under Article 77 of the Constitution. So, what is the answer in this case? It is option A. Which of the following correctly states the formula of value of vote of a elected MLA in the presidential election? What is the value of vote of an MLA? Anyways, it is on the basis of population. Population divided by total number of elected MLAs in that particular state multiplied by 1 by 1000 or divided by 1000. So, what is the answer? The answer is B or C? It is option B. It is either divided by 1000 or multiplied by 1 by 1000. Okay. Answer the following statements regarding the value of vote of the elected member of the parliament in the presidential election. So, how do you calculate the value of vote of the MP in the presidential election? The value of vote of all the elected MLAs is first aggregated. Yes. The total is divided by the total number of elected members of both houses of the parliament. If they give the total number of MPs in both houses of the parliament is wrong. It includes only the elected members. Alright. So it is true. Nominated members of the parliament are included while calculating the value of vote of MPs. No, only the elected MPs. Okay, so therefore it is 1 and 2. So all the MLAs values added on the top divided by the elected MPs, which is going to be a constant. So how many elected MPs are there? 543 plus 543 plus 233. So if you add up, I think 776 is the number, okay, in the denominator. So what is the answer? It is 1 and 2 only. Which of the following is not the duty of the Prime Minister under Article 78? So which of the following is not the duty? To countersign every ordinance personally before it is promulgated. It is not the duty of the Prime Minister. There is no obligation for the Prime Minister. Anyways, promulgating ordinance is authority of whom? It is authority of the President. Although done on the aid and advice of the Council of Ministers, it is for the President to do it. The Prime Minister doesn't have to do that. Under Article 78, there are certain other obligations. He has to inform the President of the various affairs of the state, and probably then whenever the President call upon to explain certain things, he has to inform with regard to legislations and all those things. If the President feels that some of the bills or some of the proposals has not been collectively discussed by the ministers, he may refer it again back. So these things can be done by the Prime Minister under Article 78, but not countersigning a bill. Sorry, countersigning what is an ordinance. Consider the following statements. Once an order on instrument is made in the name of the President, is authenticated in the manner specified in the rules, that is according to the transaction of business rules, its validity cannot be questioned on the ground that it was not made by the President. Yes. So this is all given under Article 77. Validity cannot be questioned once it is. Article 77 deals with authentication of executive orders of the Government of India. Article 77 deals with authentication of executive orders. Yes, because it provides for the transaction of business rules. So it only allows for the authentication, who shall authenticate and all those things. Article 77 applies only to legislative acts passed by the Parliament. Article 77 does not deal with the legislative acts. Okay, that is all given. Larger principles are laid down in the Constitution. This is not the case, but yes, Article 1 and Statement 1 and 2 are correct. Which of the following statement is correct regarding the calculation of vote of values in the presidential election? What is the right thing? The value of votes of MPs and MLAs is left entirely to parliamentary law and has no constitutional basis. The Constitution itself lays down the principle of uniformity among the states and parity between the union and the states in the presidential election, because we already seen the way this entire value is given to MPs and MLAs is to ensure parity not only between the states, but also the states put together on the one side and the union on the other side. All right. So with that, we are done with the 100 questions. We'll take a short break. We'll have to go further. So how much time do you need for break? 5 minutes, 10 minutes, 15 minutes? Because the live session is also there, we cannot give a lot of break. So we'll take a 15 minutes break. Okay, take a 15 minutes break, because we'll have to do as far as the other questions are concerned, and we'll continue. Okay, the time is what? 6:28. Okay, you can come at 6:45. Okay. Online students audible? Kindly respond to the comments. Online students audible? All right. Okay, please listen. We'll continue from the next question. Those who want to ask some personal doubts after the end of the session, you can ask. Okay, I'll give you time. Others, those who are coming in without disturbing others, please settle down. All right. So, shall we move to the next question? Okay. I'll try to cover. We'll have to cover till 200, but as far as possible, we'll try to cover. Come to the next question. Which one of the following best describes the constitutional position of Prime Minister in relation to the Council of Ministers? What is the answer here? The Prime Minister is elected separately by the Lok Sabha after general election. Is it true? The Prime Minister is the head of the Council of Ministers. Yes. In fact, here there is one area where UPSC has been asking is the Prime Minister is elected. Is the Prime Minister elected in our country? Is the statement correct? The Prime Minister is elected. The Prime Minister is not elected. The Prime Minister is appointed. They are only elected as a member of parliament, and for that matter, even someone who is not a member of parliament can also be appointed as a Prime Minister for a period of 6 months. Therefore, the Prime Minister is not elected. The Prime Minister is appointed by the President. And do you know who can be appointed as the Prime Minister? Nothing is given in the Constitution. The Constitution only says that the Prime Minister shall be appointed by the President, but who shall be is not given. It's only a conventional practice, a very strong conventional practice that we follow today. Usually a leader of the largest party having the majority or the leader of the largest coalition usually is appointed as the Prime Minister. But the President can exercise a discretion here, which is largely not given in the Constitution, a situational discretion. When there is a hung parliament, when no party or no coalition is having the majority, he may use the discretion. Is that clear? So, this is basically what you have to understand. So, here the right question is the Prime Minister is appointed who usually heads the Council of Ministers. Who appoints the other Council of Ministers? The other Council of Ministers are also appointed by the President, but on the advice of the Prime Minister. Which one of the following is correct regarding the appointment of ministers under Article 75? Very, very important. Just from Article 75, many questions can come. Even a lot of constitutional provisions are there, but at least we'll try to cover most of the things through the questions. First thing is, all ministers are elected from the Rajya Sabha. No, not necessarily. Mostly they are from Lok Sabha, in fact, but nothing is given in the Constitution. Okay. All that is given in the Constitution is that the other ministers are appointed by the President on the advice of whom? The Prime Minister. The ministers are appointed by the President on the advice of the Prime Minister. Okay, so this is definitely given in Article 75. A lot of other things which through subsequent question we will understand. So please come to the next question. Consider the following statements again under Article 75. The Council of Ministers are collectively responsible to the Lok Sabha. If a question comes that under the Constitution the Council of Ministers are collectively responsible to the Parliament, that is wrong. Under the Constitution, the Council of Ministers are collectively responsible to whom? To the Lok Sabha, which is specifically given in Article 75. But suppose if a question comes on philosophy, that on principle, not on the Constitution, that in a parliamentary system that the Council of Ministers are accountable to the Parliament, then in principle it is right. But as per the Constitution, if they use the word, it is specifically to which house? Only to the Lok Sabha. So therefore, this particular statement is correct. A minister for any period of 6 consecutive months is not a member of either house of the Parliament, ceases to be a minister at the expiration of such period. Yes, Article 75 allows even someone who is not a member of Parliament can still be appointed as a minister, but how long they can be appointed as a minister? Maximum 6 months. Within 6 months, they have to become a member of either house. They have to become a member of either house, not necessarily elected. They have to just become a member of, they can be nominated also. So, a person who is not a member of Parliament, can he be appointed as a minister for a period of 6 months? Yes, but this does not apply to someone who is disqualified under the anti-defection law. This is an exception again given under Article 75, which means if somebody is disqualified under the anti-defection law, that means he is not a member of parliament till he gets elected. A person who is disqualified under the anti-defection law, can he be appointed as a minister? Because the constitution in general says what? Even if someone is not a member of parliament, they can be appointed as a minister for how long? For 6 months. But this principle does not apply to whom? Someone who is disqualified under the anti-defection law. A person who is disqualified under the anti-defection law, try to understand, can be appointed as a minister only he gets elected to the house. He has to get again elected to the house in the particular session, in that particular I would say during that particular tenure of the house, either to the Lok Sabha or to the Rajya Sabha, but he has to get elected to the house. Is that clear? So, but otherwise this particular statement is true. The salaries and allowances of the ministers are determined by the president by an executive order. It is determined by a parliamentary law, not by the president. So, this is wrong. All these things are there in Article 75. What is the answer here? It is 1 and 2, that is 1 and 2 only. Oh, sorry, it is in, so you have to be very careful. I can make such mistake, no issues, but you cannot afford to make that particular mistake. So, what is the answer? It is 3 only. All right. So, B is the right answer. Now, what I wanted to add to this, there is also constitutional limit on number of ministers, which is again given in Article 75. What is the constitutional limit on number of ministers? It shall not be more than 15% of the total strength of the Lok Sabha. But you should also remember that this was not there in the original constitution. When this limit was brought in? By the 91st Constitutional Amendment Act in 2003. So, remember the amendment 15% as well. In case of states, it is little different, but anyways, I will discuss that later. All right. Which one of the following is not the duty of the Prime Minister? So, anyways, you already seen this, but what is the answer in this case? To pardon persons convicted under the National Security Act. It is not definitely the role of the Prime Minister. Okay. So, but the other things are his function under Article 78 of the Constitution. So, the answer in this case is option D. Come to the next question. Which of the following statements regarding the Council of, consider the following statements regarding the Council of Ministers. The Constitution separately defines the term Cabinet, Council of Ministers and Ministry. It is not defining anywhere. In fact, the Council of Ministers word is used, but it is not defined separately. Cabinet word is also used. Some explanation is given, but no definition as such. The only article where the word cabinet is used is in which article? Article 352 in the Constitution. And then it does not define the ministry also. So, anyways, this particular statement is what? Separately defines as wrong. The word cabinet appears in the Constitution. Is it true? Which is article? Article 352. Only once, that is in Article 352. And that too was not in the original Constitution. Do you know when it was inserted? Very good. 44th Constitutional Amendment Act, where they said that henceforth, if the national emergency is to be proclaimed, it shall be on the written recommendation of the cabinet. The Council of Ministers include all the categories of ministers, whereas a cabinet is the smaller inner body of senior ministers. Is it true? Yes, but that this explanation is not there in the Constitution. The statement is separately true. So, therefore, yes. Now, in fact, all these things are based on largely on the transaction of business rules, nothing more. It is not directly given in the Constitution. So, which of the statements given above are correct? What is correct here? It is 2 and 3 only. Which of the following correctly reflects the rule regarding the membership of parliament and ministership? So, largely the membership of parliament is governed under Article 84 of the Constitution, and with regard to ministership also we will see. A minister must necessarily be a member of Lok Sabha at the time of appointment. Not necessarily, he can be from Rajya Sabha also. He may not be even a member of parliament also, we have seen that. A person who is not a member of either house can be appointed as a minister, but must become a member of either house within 6 months. Is it true? Yes. What is the only exception to this? That in case of anti-defection law, we have seen how it is different. All right. Consider the following statements regarding the cabinet committees. This is again very important. Cabinet committees are extra constitutional bodies. Is it true? What do you mean by an extra constitutional body? Not there in the constitution, not flowing from the constitution, or not through the statute also. Even if it is through a statute also, we do not call it as extra constitutional. We say that it has to be a statutory body or a statutory backing. Extra constitutional means not backed by the constitution, not backed by any law. So is it true that it is extra constitutional? Yes, the cabinet committee system is completely extra constitutional. All right. So they are not mentioned in the constitution. Definitely there is no mention in the constitution. It is only for the convenience that these cabinet committees can be created. When I talk of cabinet committees, they are all executive bodies, because the cabinet committees includes whom in the cabinet committees? It is only the ministers who are part of the cabinet committees, where most of the cabinet committees are headed by the prime minister himself. So largely they can increase, they can decrease based on the power that is given to the president under the transaction of business rules, but doesn't mean that the constitution is directly allowing for it. Is it clear to all of you? So they are not mentioned in the constitution, that is also true. They are extra constitutional, that is also true, because they are purely by executive orders only. They are not mentioned in the constitution. They are set up under the government of India transaction of business rules. So who will actually determine the cabinet committees? It is the president who is to determine the transaction of business rules under Article 77. But specifically, if you look into the transaction of business rules based on the president order that he has made, he has still delegated this power to the prime minister. So who will increase or decrease the cabinet committees? It is the prime minister. So most of the cabinet committees are headed by the prime minister himself, but sometimes the prime minister may ask certain committees to be headed by other ministers as well. So if you see today, most of the committees are headed by the prime minister himself. Can you name some of the cabinet committees today? Which is the most important cabinet committee? Public Accounts Committee is a parliamentary committee. It is not a cabinet committee. That is why I said that cabinet committees are executive committees, but parliamentary committees are legislative committees. Okay, so that is entirely different. Which is the most important cabinet committee? Cabinet Committee on Political Affairs. That is the most important cabinet committee. Okay, so Cabinet Committee on Political Affairs is the cabinet committee which takes all the most important political decisions. When I say political decisions, most important policies like reservation or any other important decisions is all taken by the Cabinet Committee on Political Affairs. Then you have a lot of other committees like Cabinet Committee on Security, Cabinet Committee on Economic Affairs, but the most important committee is Cabinet Committee on Political Affairs. Then you have cabinet committees on appointments and all those things. Parliamentary committee is not a very important committee. Cabinet Committee on Accommodation is not a very important committee. So these are all sometimes may be given to the other cabinet ministers also. The Cabinet Committee on Political Affairs is very, very important. All right. So what is the answer in this case? It is option C. Which one of the following is correctly identified as a cabinet committee in the government of India? So what is the answer here? Appointments Committee of the Cabinet. So what is the role of this Appointments Committee of the Cabinet? Does anyone know? It is this committee which will give approval for the higher level appointments in the government. All right. So then they will propose it. Probably if the president has to appoint, they will propose, or even if the government has to appoint. So this committee will first approve that, which is headed by the Prime Minister himself. Answer the following statements regarding the collective responsibility. What is your understanding of collective responsibility, which again comes from Article 75, which talks about that the Council of Ministers shall be collectively responsible to whom? To Lok Sabha, which means one aspect of that is that they should always have a majority in the Lok Sabha. But how to test this majority? Nothing is directly given in the constitution. This collective responsibility is always checked by the tools that is allowed by the rules of the Lok Sabha, by which they introduce what is called as a no confidence motion. At any time the opposition can introduce a no confidence motion and see whether the government is having the majority. So the government shall always have the majority in the Lok Sabha, which is the collective responsibility. But apart from that, you should also understand that every minister, the entire Council of Ministers are collectively responsible, and there is also an individual responsibility. The individual responsibility of the minister is to whom? The individual responsibility of the minister is to the president, not to the prime minister. To whom is the individual responsibility? President, because who appoints the individual ministers? The president. Therefore, the individual responsibility is to the president. But again, though the individual responsibility to the president, we know that the president can remove the minister, but the president cannot do it on his own. On whose aid and advice he can do that? Only on the advice of the prime minister. That means individually he is responsible to the president under the constitution, but though the power lies with whom? The prime minister. Therefore, individual responsibility means individually if the prime minister is not happy with any of the ministers, or if there is any differences of opinion between the cabinet, that is a prime minister and individual minister, then the prime minister can advise the president to remove him. So, both the principles are very important, collectively as well as what is called as individually. Is that clear to all of you? And collective responsibility not only means that they have the majority, and collectively they have to back a particular decision. Though a minister may have individual differences of opinion, once a cabinet has taken a decision, an individual minister cannot oppose that. So then that goes against what is called as collective responsibility. The only way, if a minister has an individual difference of opinion, then what he has to do? He has to resign. There is no other way. Say for example, Dr. B.R. Ambedkar resigned, Mr. Nehru cabinet during the first when the government was formed. So similarly, there was a minister called as John Mehta, who was the finance minister of India at that point of time. He also had difference of opinion with regard to the role of planning commission, which is an extra constitutional body playing an important role. So he resigned. So collective responsibility means not only to the legislature, that's the most important thing, but collectively they should all back the decision of the government. If they have any individual difference of opinion, that is only before taking the decisions, not after taking the decisions. Is that clear? So it means that all ministers stand together as a team in relation to the Lok Sabha. Is that clear? Yes. So that is true. Article 75 provides for collective responsibility of the Council of Ministers to the Lok Sabha. This collective responsibility is through the no confidence motion that can be tested, although the word no confidence motion is nowhere mentioned in the constitution. And you also know that the no confidence motion can be introduced only in which house? Only in the Lok Sabha. It implies that a minister may publicly oppose a cabinet decision and yet in the office as a matter of constitutional right, that he cannot oppose it publicly. They may have difference of opinion which is behind the screen, but before the screen they should all support each other. Okay, so that is why you will understand that once a government takes a decision, there is an obligation for others to support it as well. So what is the answer here? It is 1 and 2 only. Which of the following statement is correct regarding the ministers holding office during the pleasure of the president under Article 75? What do you mean by pleasure of the president? Here the pleasure of the president means that who is appointing authority for the ministers? President. And who is the removal authority for the president? President. So, but here the pleasure of the president doesn't mean that they can be removed at any time. Although if the question comes that the ministers hold office during the pleasure of the president, that is true. But you'll have to understand as to what is the real meaning behind the term pleasure of the president. The real meaning behind the word pleasure of the president is collectively the president may have the pleasure when they lose a majority that he can dismiss the government. Individually any particular minister can be removed if who is not happy with the minister? The prime minister is not happy, then also the president can remove on the advice of the prime minister. Is that clear? That is how you'll have to understand the pleasure. So what is the answer here? It operates in the constitutional framework of parliamentary government where ministerial continuance is tied to the prime minister's advice and the logic of collective responsibility. So here when you talk of the continuance tied to the prime minister's advice is with regard to the individual responsibility. Collectively they need to have the majority. All right. Which of the following statement is correct regarding the appointment of the governor? So who appoints the governor? The president, the governor is appointed by the president by a warrant under his hand and seal. So what does it mean by warrant under his hand and seal? That means the appointment has to come from the office of the president himself and signed by the president himself. He cannot delegate that. Though most of the executive authorities are delegated to others, but this is not one such power. Is that clear? So the answer here is option. Consider the following statements regarding the office of the governor. There shall be a governor for each state. There shall be a governor for each state. Yes, of course, there has to be a governor for each state. Who is the constitutional head of the state? The same person can be appointed as a governor for 2 or more states. This provision was not there in the original constitution. When this was brought in? Very good. By the 7th Constitutional Amendment Act 1956. A governor must be a sitting member of parliament at the time of appointment. No. You know what is the qualification for the governor? Only two things are there. He is completed 35 years of age and a citizen of India. Nothing more than that is given in the constitution. Do not confuse, because there are number of recommendations which is given by various center state commissions with regard to the governor, but none of those things are part of the constitution except for these two things. Is it clear? So there is no need for a person who is a sitting member of parliament. But can a sitting member of parliament be appointed as the governor? Is it possible? Yes. A sitting member of a parliament or a state legislature can be appointed as a governor. Do not confuse this with a recommendation that is given by the Sarkaria Commission, where the Sarkaria Commission said someone is actively retired from politics. That is only a recommendation, not a constitutional provision. But the only thing that you have to keep in your mind is, if a member of parliament or a member of state legislature is appointed as the governor, then the moment they are appointed as a governor, they cease to be a member of parliament or a member of state legislature. So what is the answer in this case? It is 1 and 2 only. Which of the following is a constitutional qualification for the appointment of the governor among the thing? So he must be a citizen of India and have completed 35 years of age. Sorry. Which of the following statement is correct regarding the tenure of the governor? So two things that you'll have to keep in your mind with regard to the tenure of the governor. If you read the constitution says that the governor shall hold a term of 5 years, but that is subject to the pleasure of the president. Therefore, if you combinedly read subject to the pleasure of the president, we say that there is no security of tenure to the governor. But otherwise, what is the term of the governor? The term of the governor is usually 5 years, but subject to what? The pleasure of the president. That means though the term is 5 years, it is not necessary a governor may complete his 5-year term, because the governor can be removed by whom? By the president at his pleasure. Alright. But however, the Supreme Court has already said, though the governor would continue to hold the office during the pleasure of the president, but it doesn't mean that this pleasure can be arbitrarily exercised. But however, he continues to hold office during what? The pleasure of the president. So what is the answer here? The governor holds office during the pleasure of the president, though the normal term is 5 years. Consider the following statements regarding the governor's emoluments and allowances. The governor is entitled without payment of rent to use the official residence. Yes. The emoluments and allowances of the governor are determined by parliamentary law. Yes, it is the parliamentary law, no doubt in that. Okay, it is only the parliamentary law. The emoluments and allowances of the governor cannot be diminished during his term of office. But in one case, the president is involved. When the same person is appointed as a governor for 2 or more states, in those cases, some extra allowances that may be payable. Who shall determine that? The president by an order determine that. Otherwise, normally it is determined by the law that is made by the parliament. What is the answer in this case? It is option D. Which of the following best describes the constitutional position of the governor regarding his executive powers? The executive power of the state is vested in the Council of Ministers. See, though they may exercise, the constitution does not say that. The constitution clearly says that the executive power shall be vested in the governor. The executive power of the state is vested in the governor and is exercised by him either directly or through the officers subordinate to him in accordance with the constitution. Yes. So this is by virtue of article, I think 154 in the constitution. 152 in the constitution or 154 in the constitution. But anyways, the article is not important. This is the constitutional provision. So come to the next question. With reference to governor assent to the state bills, consider the following statements. Okay, if a question comes, please try to understand unless and until they explicitly ask what is given in article, which article gives the power? 200. But even what is given in the article has to be read along with the presidential opinion which has been given recently. So go with the presidential opinion if at all the question comes, where the presidential opinion has recently made it very clear. Now the governor can exercise only 3 options. What are the 3 options that the governor can exercise? That whenever a bill is presented, the governor can give the assent. 2, the governor has no power to withhold the assent. He has no power to what? No power to withhold the assent. Can he send it for reconsideration? Yes, he can send it for reconsideration within a reasonable time frame. or he can reserve it for the consideration of the president. Is that clear to all of you? So therefore, the Supreme Court has made it very clear, unlike the President of India, the governor has no power to exercise what is called as absolute veto. But absolute veto means what? Withholding the assent to the bill. So the governor has no power to withhold the assent to the bill. The governor has no power to even exercise what is called as packet veto, because he cannot sit on the bill ideally for a long period of time, because within a reasonable time what he has to do? He has to return it for reconsideration, provided if it is not a money bill. In case of a money bill, anyways he cannot do that. And the third option he can exercise is what? He can also reserve the bill for the consideration of the president. Reserving the bill for the consideration of the president is again the discretionary power of the president. That means he can reserve any bill for the consideration of the president if you want to reserve it. But in one case, it is constitutionally mandated for the president to reserve the bill. In which case, if the bill is trying to take away the powers of the High Court consent, then it is mandatory. In all other cases, it is only his discretionary power. Is it clear to all of you? And further, the Supreme Court said this also. Suppose if the governor has initially sent the bill for reconsideration, thereupon when the bill is sent, he has to give the assent to the bill. Then thereafter, he cannot again reserve it for the consideration of the president. Is it clear to all of you? Because these options are independent options. So once exercised, it cannot be undone. But however, there is no fixed time limit, because the Supreme Court opinion has done away with a time limit which was earlier given by a division bench in the Supreme Court, because the opinion is a 5-bench opinion. So even in the earlier incidences, some of the opinions have overruled the decisions that has been given, unless and until explicitly it has been overruled again by a Supreme Court bench. So if at all any doubt, just stick to the opinion that is given by the Supreme Court. Alright, so with that you just come here. The governor may assent the bill, is it true? The governor may reserve the bill for the consideration of the president. Yes, within a reasonable time frame, although there is no time limit, but provided in this case, if it is not a money bill, okay. Sorry, reserve the bill for the consideration of the president, any bill. So can he reserve a money bill for the consideration of the president? Yes or not? Yes, even in case of a money bill, he can reserve it. But in case of a bill other than the money bill, the governor may return it to the house for the reconsideration. Is it true? Yes, this is also true. So what are the answers? What is the answer? Option D is the answer. Which one of the following statement is correct regarding the governor's ordinance making power? The governor can promulgate ordinance only when both the house of the state legislature is not in session. Why it is wrong? Either houses. Suppose in a state where there are two houses, either of the house not in session, they can still do it. Ordinance can be promulgated only with the prior approval of the state high court. So you can easily eliminate this. The governor may promulgate an ordinance when the legislature is not in session and in circumstances requiring immediate action. Yes. This is in fact more important. So because it is not that whenever the house is not in session, they can promulgate. There should also be an immediate requirement for an ordinance. Okay, so here can you tell me the answer, which is the case we already discussed. So what is the answer in this case? The governor can grant pardon, reprieve, respite, remit, commute in respect of offences against the law relating to the matters in which executive power of the state extends. So in all the cases where the executive power of the state extends, who will have the power with regard to those things? The governor will have the power. But if it is based on a state law, suppose let us assume, if it is based on a state law where the punishment that is given is a capital punishment, so what kind of power can be exercised by the governor? The governor can commute the capital punishment, but he cannot pardon it. So pardon it is anyways is only the authority of whom? Only the president. So what if it is in regard to the court martial? The governor has no power in this regard. It is only the power of the president. Alright. So what is the answer here? The answer is option C. And also you should also remember that anyways these things are not discretionary power of the president and the governor. It is on the aid and advice of the cabinet or the council of ministers. And whatever is the decision that is given by the president with regard to the president or the governor, are they subject to judicial review? Yes, they are subject to limited judicial review. But what is this limited judicial review? Only the Supreme Court knows. But anyways, the word that they have chosen is what is called as limited judicial review. Is that clear? Which one of the following is correct regarding the governor and the state legislature? So what is the appropriate thing? The governor may address a legislative assembly or both the houses assembled together and may send messages to the house or the houses. Is it true? Yes, the same provision is there for the president also. The president can make address to any of the house and messages, and the president can also deliver an address to the joint sessions of the houses under two circumstances. Under which circumstances the president makes a joint address? First session every year and also the first session after the general election. The same thing is done by the governor also, which you also understand that once that address is made, that in both the houses a motion is introduced. What is that motion? It is motion of thanks. And what is the consequence if the motion of thanks is not passed? In the Lok Sabha, it is automatically deemed to be a no confidence motion, and if it is not passed in the Rajya Sabha, it is no consequence, no political consequence, maybe an embarrassment if the government takes it as an embarrassment. So similarly, the same is case with the legislative council as well. All right. So what is the answer in this case? It is option B. Answer the following statements. Now, this Attorney General and Advocate General also you can expect one question. Very small topic, but these are all areas UPSC asks. So the Attorney General is appointed by the President. Yes. Who is Attorney General? Highest law officer of the Government of India. That is a Chief Advocate of the Government of India. Okay. A person appointed must be qualified to be appointed as a judge of a Supreme Court. Yes, the only qualification they are given is that he or she should have a qualification to be appointed as a judge of a Supreme Court. But anyways, what is the qualification to be appointed as a judge of a Supreme Court is separately given. But here in this article, it has been given, he is to be appointed as a judge of a Supreme Court. Attorney General holds office during the pleasure of the President. Is it true? Yes. No tenure is given, nothing is given. It is all to be decided by a presidential order. It is the President who will decide. So the Attorney General also holds certain privileges, which we will understand through the other question. So what are the privileges that is given to the Attorney General? So come to the next question. Which one of the following best describes the powers and privileges of the Attorney General? He can vote in both houses of the Parliament but cannot speak. But rather he can speak whenever he is considered to be a member of that particular committee or the house, not member when he is called upon to defend the government or to take part in the parliamentary proceedings. They have the right to speak without what? Without right to vote in that particular house. Okay. Otherwise, they can exercise all the privileges also. There is an article in the constitution which does give certain privileges to the members of the parliament. Which is the relevant article? Very good. Article 105. Can anyone tell me what are the privileges that is conferred under Article 105? Two privileges are explicitly conferred. Right to freedom of speech and to vote in the house, for which there can be no proceedings in a court of law. That is one privilege. Very good. What is the other privilege? Okay, we will go to the second privilege, but is this privilege absolute in nature? It is subject to the rules of the house and the provisions of the constitution. Does this privilege can be exercised outside the parliament, or is it only within the parliament? Only for whatever is spoken in the house, not outside the house. Second is right to publication. They have the right to publish the true reports and proceedings of the house and its true reports and all those things, subject to what can be expunged by the presiding officer. These two privileges are explicitly given in the constitution. Now, the presiding officer may also exercise all these privileges when he is part of any parliamentary proceedings or taking part in any discussion, except without what is called as the right to vote. He or she does not exercise the right to vote. What is the answer here? The answer is option B. Which of the following statement is correct regarding the Advocate General of the state? He is appointed by the Chief Minister and holds office during the pleasure of the Chief Minister. Or rather, he is appointed by the Governor. He must be qualified to be appointed as a judge of a Supreme Court. He is appointed by the Governor, must be qualified to be appointed as a judge of High Court and holds office during the pleasure of the Governor. Yes. Consider the following things, statements regarding the Governor of a state. The Governor is part of the state legislature. Is he part of the state legislature? Because if you see the constitution says the state legislature comprise of governor, legislative assembly, and where there is a legislative council, also the legislative council. The governor is part of the state executive. Yes, it is very much true. In fact, he is the head of the state executive. Now, if you ask me a question how he can be part of both legislature and executive, that is very much possible because we have a parliamentary democracy. And in a parliamentary democracy, there is no clear separation of powers. We rely more upon the principle of checks and balances. And in fact, there is an overlap between what is called as a legislature and the executive. So that overlap also is there. But however, you'll have to understand, though he is considered to be part of the state legislature, he is not a member of state legislature. Okay. The governor is part of the high courts. Is he also part of the judiciary? No, judiciary is separate. Okay. So not part of the judiciary. So what is the answer here? It is 1 and 2 only. Alright. So come to the next question. Which one of the following statement is the most accurate regarding the governor's relationship with the council of ministers? What is the answer? The governor acts on the aid and advice of the council of ministers except in the matters where the constitution requires him to act in a discretion. What is the relevant article here? Okay. Any student who has parked a Baleno car, Maruti Baleno. Is there anyone in this class? What is the number? 8055. And also it is a request from the management that students are not provided with the parking. It is for the people are car parking. So if anybody car is parked, I think it is blocking the way. So no one in this class? Color? What is the, if you forget the brand and the blue color Maruti Baleno, no one in this class? No one, I think, here. All right. Okay, so which question we are discussing? 125 is done. What we are discussing? Relevant article. So this is very important because if you see the constitutional position of the president and the constitutional position of the governor, they are little different. And that difference is brought into the constitution by virtue of this article 163 in the constitution, which is determining the constitutional position of the governor is article 163, and a similar constitutional position is given for the president under article 74. There is a huge difference between article 63 and 74 and article 163, because article 74 says that there shall be a council of ministers headed by the prime minister to aid and advise the president, who shall act in accordance with such advice. That means whatever advice I give is binding. That is what it is given in principle. But this doesn't mean that the president has no discretionary powers. It only means there is no emphasis that is given upon the discretionary powers of the president, because the president is largely to act on what? On the aid and advice of the council of ministers. But that to say that the president has no discretionary power is a wrong understanding, because you should also read the entire article 74 along with the 44th Constitutional Amendment Act. What is 44th Constitutional Amendment Act is saying? That any advice that is sent to the president, he can send it once for reconsideration. So do you think that that will also be advised by the council of ministers? Okay, you send it once for reconsideration, again we'll give the recommendation. That is anyways is discretionary power. But the emphasis is not on the discretionary power of the president. Largely his act as what? A nominal executive. But that is not the case with the governor. If you see the governor, the relevant provision is article 163 in the constitution. Now what is article 163 in the constitution is talking about? Article 163 in the constitution is saying that there shall be a council of ministers headed by the chief minister to advise the governor in exercise of his function, except in those areas where he can exercise his discretion. That means here it is not that it is saying that every advice is binding. The advice is binding except in those areas where the governor shall exercise his discretion. So, wherever he can exercise the discretion, there the advice is not binding, and there are a number of articles which specifically give the discretionary power to the governor also, like say for example, recommending for the imposition of president rule, reserving the bill for the president. In these areas the discretion is there, in those areas he does not act on the aid and advice of the council of ministers. So, specifically wherever the discretion is not given in the constitution, in those areas he is bound by what? The aid and advice of the council of ministers. Therefore, the idea that you will have to have is relatively the discretion for the governor is emphasized more in the constitution relatively to that of the president. It does not mean that the president has no discretion. He also has discretion by virtue of the 44th Constitutional Amendment Act and by virtue of certain other articles also. Say for example, Article 111. Under Article 111, what is the option that the governor, the president can exercise whenever bill is presented? He can send a bill once for reconsideration, provided it is not what type of bill? It is a money bill and also constitutional amendment bill. That is his discretion only. But the way that the constitution is designed is the president to act more as a nominal executive, but the governor is also nominal executive, but he has got more discretionary powers. All right. This is what you will have to understand. So, relatively he is having more constitutional discretion. To say that the president has no constitutional discretion is not a right understanding. Is it clear to all of you? So, this is what you will have to understand. So, with that, what is the answer here? It is option B, but try to understand the position of the governor. Alright. So, this is for the reason, if you want further, just a moment, that this is for the reason, unlike the president who is head of the union executive, he is just the head of the union executive, but whereas a governor is not merely the head of the state executive, he is also to represent the interest of the center in the states. He is also to act as a link between the center and the states. So, there are, wherever he has to exercise his function as a representative of the center in the states, so he is given discretion. All right. So, that is what you will have to understand. So, come to the next question. So, now we are going to the legislature. Shall I go to the legislature? Executives are largely done. We will go to the legislature. We will try to cover as much as possible. Okay. So, that we are able to cover all the 500 questions. So, first 400 questions is largely in each and every article I have picked up the questions. The last 100 question, as I already said, it will be again a revision of whatever we have seen. Okay. So, it will be like a very important areas again picked, but these are all small areas which UPSC can ask. Okay. Which of the following correctly states the constitutional position of parliament in India? So, what constitutes parliament? Basically, it is a president, Lok Sabha and the Rajya Sabha. That is what constitute. So, as I already said, is the president an integral part of the parliament? But he is not a member of parliament. Consider the following statements regarding the Rajya Sabha. The maximum strength of Rajya Sabha is 250. Is it true? Yes. Out of these, 12 members are to be nominated by the president on the advice of the council of ministers and from the areas of art, science, literature and social service. The representatives of the state in the Rajya Sabha are directly elected by the people. Is it true? The representatives in the Rajya Sabha are indirectly elected. So, what is the system of election? Proportional representation by means of single transferable vote, and the election is indirect election. All right. But unlike the president, try to understand, unlike the president election, it is not by what is called a secret ballot, rather it is by open ballot. So, those who already attended my class, you might be knowing it. So, what does it mean by an open ballot here? Although the constitution does not directly say that, it is given under the Representation of People Act, which is talking about the open ballot. So, what is the open ballot system here? They have to show the vote to the party agent, authorized party agent. If they do not disclose it to the authorized party agent, then it becomes an invalid vote. If they declare it to anybody else apart from the authorized party agent, then also it is an invalid vote. Is it clear? The point that you have to remember further is that though it is an open ballot system, if they cross vote, will it attract the anti-defection law? It won't attract the anti-defection law. What is the reason for that? Because the election to the Rajya Sabha, that is voting in the legislature to the Rajya Sabha, is not considered to be a legislative proceeding. The Supreme Court has already declared it is not considered to be a legislative proceeding, because anti-defection law applies when you do not follow the whip directions when it comes to what is called as legislative proceedings. Legislative proceedings means as a legislative body, what is the function they are supposed to perform? As a legislative body, what is the function they are supposed to perform? Passing bills, debates, motions and all those things. Here you are just merely acting as an electorate. So, you are exercising the vote, which is not a legislative function in itself. That is the explanation that is given by the Supreme Court. Just try to remember this. So, what is the answer in this case? Which of the statements given above are correct? It is 1 and 2 only. Which one of the following is correct regarding the election of representatives of states to the Rajya Sabha? So, what is the answer here? They are elected by the elected members of Legislative Assembly by proportional representation through single transfer vote, but the voting is by open ballot. Not given in the constitution, but it can be further decided by the law that can be made by the parliament, and the relevant law here is the Representation of People Act 1950. Consider the following statements regarding the qualification of membership to the parliament. So, do I want to repeat something? Okay. So, come to the next question. Consider the following statements regarding the qualification for membership of parliament. A person must be a citizen of India. Yes. A person must make and subscribe. A person must make and subscribe an oath or affirmation in the form set out for the purpose. Yes. So, in fact, they have to subscribe to an oath as given for that particular purpose, as I think it is given in the schedule 3 of the constitution. They have to make an oath. They have to make an oath in front of an authorized authority as appointed by the election commission. The person shall not be less than 30 years of age. The person shall not be less than 25 years of age. Okay, so here it is wrong. So, what is the answer? Is incorrect. It is 1 only. Which of the following is not a ground for disqualification for membership of parliament under Article 102? Now, remember, there is a lot of disqualification to contest election and to become member of parliament, but there are certain things that is given in the constitution itself, and a lot of things comes from the Representation of People Act. But the moment they talk about Article 102, strictly restrict to what is given in the constitution. Not they have asked holding an office of profit. It is given directly in the constitution, so not unsound mind, being an undischarged insolvent, being over 70 years of age. There is no such provision either in the constitution or in the law. Okay, it is just a distractor. Okay. Answer the following statements. If any question arises as to whether a member of either house of parliament has become subject to a disqualification under Article 102, the question is decided by the president. If a question arises as to whether a member of either house of the parliament has subject to disqualification under Article 102, the question is decided by the president. This is true or false? This is the general rule. But suppose if they ask that in all the cases, it is wrong, because under Article 102, there is also a ground for disqualification by anti-defection law, because anti-defection also comes from Article 102, but further elaborated under the 10th schedule. So, in case of anti-defection, who is the disqualifying authority? The presiding officers, but yes, generally the rule is true. Okay. And in this case, how the president decides? Say, for example, in case of office of profit or in case of declared competent court for any mental disorders. So, the president is the deciding authority, but on the hidden advice of the Council of Ministers, how he decides? On the recommendation of the Election Commission of India, except this does not apply in case of anti-defection law. So, yes, generally it is true. The president decision in such cases is final under the constitution. Is it true? Of course, they can go for an appeal, but there is no other authority except going for the judiciary. Alright. The question is decided by the speaker of the Lok Sabha in all such cases. The question is decided by the speaker. The question is decided by the speaker only in which case? Only in case of anti-defection law. There also it is not right. In anti-defection law also, it is not in all the cases. The speaker will have only in Lok Sabha. It is a presiding officer. Is that clear? So, be mindful of that also, even in case of anti-defection law. So, which of the statements given above are correct? It is 1 and 2 only. Yes, the recommendation of the ECA is binding upon the president. Similarly, the recommendation of ECA is binding upon the governor with regard to the state legislature. Which one of the following statement is correct regarding the simultaneous membership? So, simultaneous membership, which article in the constitution talks about this, if you can recollect? For the members of the parliament, it is article 101 of the constitution, which talks about the vacancy in certain cases. One of the ground is simultaneous election. So, we will try to recollect that. A person may be a member of both houses of the parliament permanently if elected to both. It is not possible because article 101 makes it very clear. If a person get elected to both the houses of the parliament, then in that particular case, he has to resign from one of the house. But there are two conditions that you will have to understand. He has to resign from one of the house in such a manner as may be prescribed by the law. The constitution does not give everything, but further the law prescribes for it, which is a representation of people act 1951. It is specifically dealt under section 68 and section 69 of the representation of people act. The specific section is not very important, but just try to remember the provision. If a person simultaneously get elected to both the houses, that means he is not a sitting member of any of the house, he gets simultaneously elected to both the house. So, whenever he get elected to the second house, it might be possible on the same day the result is announced, or on the different day the result is announced. So, if the result is announced on a different day, but he has not taken at the membership of any of the house when the result was announced. So, whenever the result is announced for the second house, from that day within a period of 10 days, he has to declare which house he wanted to take it up. Otherwise, the house in the Rajya Sabha is deemed to be vacant automatically. If he otherwise tells, so it is his choice, but otherwise which is automatically considered to be vacant in the Rajya Sabha. And what is the time limit? 10 days. Second thing, it is also possible a sitting member of one house get elected to another house. If a sitting member of one house get elected to another house, now in that particular case, then automatically the second house, because the to whichever house is already a member becomes vacant. Is that clear? Then okay, so in this case a person may be a member of both houses of parliament permanently if elected to both. Is it clear? He cannot be, so this is wrong. A person may simultaneously be a member of parliament and state legislature. That is also not possible. If a person, a sitting member of parliament get elected to the state legislature or vice versa, whatever may be the case, when he gets elected to the other house, in that particular case within 14 days they have to declare that which house they wanted to take. Otherwise, what is assumed by the law? Otherwise, the parliament seat will become vacant. Okay, so this is also not possible. A person chosen as a member of both the houses of the parliament must vacate. Both houses of the parliament must vacate one seat and the manner provided in the parliamentary law. So, but what is this? A person, a member of both houses of the parliament, is permanently elected. So, a person who is chosen as a member of both houses must vacate one of the seats. So, this is what you have seen. What is the time limit within which he has to vacate? 10 days. Apart from this, there is also one more thing which is given under the representation of people act. A person can get elected from two constituencies. If a person gets elected from two constituencies, in that particular case, what is likely to happen? If a person is elected from two constituencies, then in that particular case, so he has to again declare which seat he wanted to take within a period of 14 days to the speaker or any of the other authority as may be prescribed. Within 14 days, if he does not prescribe, then what will happen? Both seats will become vacant. Okay. So anyway, so what is the answer in this case? It is option C. Okay, so come to the next thing with reference to delimitation is a very important topic this year. Okay, so because of all the issues, they may not even ask from the bill because it's still a bill, but they may generally ask from the delimitation provisions. Okay, anyways, you know what is the issue with reference to the delimitation and the freezing of seats. Consider the following statements. The 42nd constitutional amendment froze the allocation of seats and delimitation on the basis of 1971 census till the year 2000. Is it true? Has it frozen? Yes. Till the year 2000 it has frozen it. So, this is true. The 84th Constitutional Amendment Act extended this freeze until the first census after 2026. Is true? Yes. The 87th Constitutional Amendment Act shifted the basis of readjustment from 1991 census to the 2001 census without changing the total number of seats allotted to each state. Is it true? The 87th Constitutional Amendment Act shifted the basis of readjustment from the 1991 census to the 2001 census. It is not 2011 census. Okay. So this is in case of redrawing of boundaries and also with regard to allocating seats to the scheduled caste and scheduled tribe. All right. So this is again wrong. So the present bill, that is the 131th Constitutional Amendment Bill, they are trying to fix this 2001 census, sorry 2011 census. But anyways, the bill is already defeated, so it may not be of much significance. But in general, from delimitation, whatever is already existing, it can be asked. So what is the answer here? Answer is option A. Which of the following statement is correct regarding the House of People? What is the answer? Its composition is determined entirely by the ordinary law. No, its composition is there in the Constitution. Its members are only nominated. No, the Constitution provides for direct election from territorial constituencies in the states. Yes. Which one of the following statement is correct? Both houses of parliament have normal tenure of 5 years. The Rajya Sabha can be dissolved by the president. Rajya Sabha is a permanent house. The Lok Sabha, unless sooner dissolved, continues for 5-year term from the date appointed for first meeting. Yes. So normally the tenure is 5 years, but it can be dissolved. Can it be extended? Under what condition it can be extended? When there is a national emergency. And who is authority to extend it? Parliament is the authority by way of a law. And how long it can be extended? Indefinitely, but 1 year at a time. Okay. So consider the following statements. Next question. Consider the following statements regarding the Rajya Sabha. It is not subject to dissolution. Yes, because it's a permanent house. It is not subject to dissolution. Sorry, it is true. It is not subject to dissolution. As nearly as possible, 1/3 of its members retire every second year. Is it true? Yes, 1/3 of the member retire every second year. This is true. Its normal duration is 6 years. How it is possible? It is a permanent house also. Its normal duration is 6 years also. The 6 years duration is only for the members, not for the house. Okay. So therefore, it is wrong. So what is the answer? So these are the mistakes we should not make in the exam, because when you do it fastly and with all the pressures, possible sometimes you will make mistakes. So do not do it. Which of the following best reflects Article 86 in the Constitution, which is regarding the president can send address to both the houses of the parliament. It is not the special address. The special address is under Article 87. This is a normal address at any time he can make or he can send message. The president may address only the Lok Sabha. No, in fact, he can address both the houses, not just the Lok Sabha. The president may address either houses or both the houses assembled together and may send messages to either house. Yes? Yes. So this is just a normal address. If he wants, he can do it anytime. Only the special address he makes on couple of occasions. Okay. So special address is different. That is during the first session after the general election and first session every year. The president special address to the parliament is constitutionally required. 1. At the commencement of the first session after the general election to the Lok Sabha. Yes. At the commencement of the first session every year. At every session in the parliament. No. So what is the answer here? It is 1 and 2 only. So after this only we have discussed what is likely to follow. After this, what is likely to follow? A motion of thanks is likely to follow. And if the motion of thanks is not passed, then it is automatically deemed to be a no confidence motion. Can the motion of thanks, can there be an amendment to the motion of thanks? When the motion of thanks is introduced, can any member of parliament can introduce an amendment to the motion of thanks? Of course, the opposition will try to introduce an amendment, because what is this motion of thanks? The motion of thanks is itself to thank the president for making an address, and where the president has brought what the government has achieved. So naturally, what the opposition will try to do? They will say that you have not achieved all these things. Will they try to introduce an amendment to that particular motion? Yes, they will try to introduce an amendment. So they can introduce, but if it is passed, then it amounts to no confidence motion. So it can always be amended. by an amendment. The amendments can be introduced to that particular motion. Which one of the following statement is correct? What is the answer in this case? Which one of the following statement is correct? The deputy chairman of Rajya Sabha is appointed by the president. That is not correct. The chairman of Rajya Sabha is elected by the Rajya Sabha among its members. That is also not correct. The vice president of India is the ex officio chairman of Rajya Sabha. Is it true? Yes. What do you mean by ex officio? By virtue of being the vice president, he automatically becomes the chairman of Rajya Sabha. Consider the following statements regarding the removal of deputy chairman of Rajya Sabha. So this year you can definitely expect question removal either from the chairman or from the deputy chairman or from the speaker or from the judges. From any of these areas you can expect a question, because all these things has been in the news one way or the other. So whatever there with regard to polity, one thing you try to understand, whatever there in the current affairs, the facts are not important. Directly they will go to the constitutional provisions, and from where the questions are likely to come. So you should be aware of the constitutional provisions. At least for your prelims, this is how the questions are coming. All right. Okay, so consider the following statements regarding the removal of the deputy chairman of Rajya Sabha. He may be removed by a resolution of the Rajya Sabha passed by a majority of all the then members. Is it true? He may be removed by a resolution of the Rajya Sabha passed by a majority of all the then members. This is what is given in the constitution. All the then members is equal to what type of majority? Effective majority. The constitution does not use the word effective majority, but all the then members means there is a majority of the effective membership of the house. So this is definitely true. If the expression is the majority of the members present and voting, then what type of majority is that? It is simple majority. If the majority of the total membership of the house, then absolute. Then for the special majority, different types of special majorities are there. All right. So 14 days notice is to be required. Is it true? Yes. This procedure has to be followed. The Lok Sabha has also to pass the same resolution. So for the speaker and the deputy speaker, the Lok Sabha will take care. For the deputy chairman, it is only the Rajya Sabha, but for the vice president, who is ex officio chairman, it will be in both the houses, although the majority is different. So suppose if it is the chairman who is also the vice president, then what is the majority in that case? Same 14 days notice and all those things, but you will have to remember it can be introduced only in the Rajya Sabha, and in the Rajya Sabha what majority is required? Effective majority, that is the majority of the then members, and then in the Lok Sabha what majority is required? Simple majority. Which of the following is correct? Statement 1. The speaker and the deputy speaker of Lok Sabha are appointed by the president. Is it true? The speaker and the deputy speaker, they both are elected, they are not appointed. The Lok Sabha shall as soon as maybe choose 2 members of the house to be speaker and deputy speaker. Is it true? Yes. Constitutionally, there is no time limit to elect both the speaker and the deputy speaker. They shall be elected as soon as possible. So if you see in the Lok Sabha, even today the deputy speaker is not elected, but it is not a constitutional violation because it is only saying as soon as possible. Alright. The speaker may be chosen from outside the parliament. That is not possible. Anyways, you know, because the only qualification is there should be a member of that particular house. The deputy speaker must necessarily belong to the ruling party. That is also not true, because constitutionally nothing is given. It is only a conventional practice that the deputy speaker post is given to whom? To the opposition party. Alright. Which one of the following is correct regarding the removal of the speaker of Lok Sabha? He may be removed by the president? No. He may be removed by a resolution passed by the Lok Sabha by a majority of the members present and voting. That is, the majority that is required is what? Effective majority. So this may not be the case. Removed by an impeachment. So that it is also called as an impeachment, but just not by an impeachment, because most appropriate thing is he may be removed by a resolution by the Lok Sabha passed by a majority of all the then members after 14 days of notice, which is the appropriate thing. Although your newspaper is reporting the word impeachment, the word impeachment is not used in the constitution. It is only saying removed by a motion which is passed by all the then members after giving a 14 days of prior notice. So what is the answer? Option D is the answer. Consider the following statements. When a resolution for removal of the speaker is under consideration, the speaker shall not preside. So he shall not preside. So who will usually preside? The deputy speaker. It is usually assumed as if the speaker is absent. In case of absence, then the deputy speaker will preside. If the deputy speaker is also not there, then who will preside? Among the panel of chairpersons, anyone will preside. When the resolution for the removal of the deputy chairman and the Rajya Sabha is under consideration, he shall not preside. Is also true? Yes. So this is also true. So this is also true. In such cases, that is when the removal motion is there, the concerned presiding officer, that means whoever be the presiding officers, the concerned presiding officers can still vote in the first instance like an ordinary member where the constitution so provides, except in the case of chairman Rajya Sabha. Is it true? That means the statement is trying to say if there is a removal motion against a speaker, deputy speaker, chairman, deputy chairman, among the 4 people except for the chairman of Rajya Sabha, the other members can present in the house and vote in the first instance. Is it true? Yes. Yes, only the chairman of Rajya Sabha is not allowed to vote in the first instance. Why? Because anyways he is not a member of parliament. But otherwise the others can vote in the first instance. But otherwise what they will do? The presiding officers usually only exercise casting vote. It is someone who is the presiding officer. That means at a time only one person can be a presiding officer. And that provision, the casting vote is not only for the speaker or for the chairman, anyone who is presiding over the house, they can exercise only what is called as casting vote. Alright. So what about this particular statement? This is also true. What is the answer? It is none. Which of the following statement is not mentioned in the Constitution of India? The speaker vacates office if he ceases to be a member of the Lok Sabha. Is it true? That is true because the only requirement is he or she should be a member of the house. The deputy speaker may resign by writing by address to the speaker. That is also true. The deputy chairman of Rajya Sabha may resign by writing address to the chairman. Is it true? True. The chairman of Rajya Sabha may resign by writing address to the president. Is it true? This is not true. This is constitutionally not true because the constitution provides for no such provision. The constitution only says that the vice president can resign to the president. It is never saying that the chairman can write it to the president because not mentioned in the constitution of India. So therefore, we know that anyways the vice president is what? The ex officio chairman. So he may submit the resignation as the vice president. Okay. So therefore, this is not directly given in the constitution. So what is the answer in this case? It is option D. The salaries and allowances of the chairman, the deputy chairman of Rajya Sabha and the speaker and the deputy speaker of Lok Sabha, what is the right answer? Shall be determined by the law made by the parliament as it in the second schedule. It may be further modified by the law till the time it is there in the second schedule. But the most important thing is all their salaries and allowances are also charged upon the consolidated fund of India, which I will discuss further when I take up the budgetary part. Okay. Which of the following statements regarding the secretariat of the parliament? Each house of a parliament can have a separate secretariat staff. Yes. Yes. The constitution in fact allows for that. Further it says that the parliament may by a law regulate the recruitment and conditions of service of persons appointed to the secretariat staff of the house. Yes, the power is given to the parliament to regulate it. But the constitution further says till the time such a law is made, the president may issue an order regarding their service condition after consulting the respective presiding officers. So what is the answer in this case? All the statements are correct. So what is the answer? Option D is the right answer. Before taking seat, every member of either houses of parliament shall make and subscribe to oath or affirmation before whom? President or some other person appointed by him in that behalf. Normally it is for the president to do that or some other person. Normally for the purpose only, if you see the president appoints someone as a speaker pro tem who normally does that. That is not required in case of the Rajya Sabha. For the reason in Rajya Sabha it is a permanent house. So, but that is required in case of the Lok Sabha. So, which is given under Article 100 of the Constitution. The Speaker pro tem is not given anywhere in the Constitution, but they have to subscribe to an oath is given under Article 100. Okay. So, what is the answer here? Option A. Which one of the following statement is correct regarding voting in the parliament? The speaker has an original vote in all cases and no casting vote. The question are decided by majority of all the then members of the house. The chairman or the speaker ordinarily does not vote in the first instance, but may exercise casting vote in case of equality of votes, that is in case of tie. Yes, this is a provision in Article 100. All these things are a provision under Article 100 of the Constitution. Unless Parliament otherwise provides, the quorum constitutes a meeting of either house of the Parliament. What is the quorum? Not less than 1/10, which can be modified by way of a law if the Parliament wants to modify that by a simple act of Parliament, but no such law has been made. The quorum constitutes even today not less than 1/10 of the members of the house. Consider the following statements regarding the Speaker of the Lok Sabha. The Speaker vacates office if he ceases to be a member of the Lok Sabha. Is it true? Because the only qualification is that he or she should be a member of that particular house. Even after the dissolution of Lok Sabha, the Speaker does not vacate office immediately and continues until immediately before the first meeting of the Lok Sabha. Is it true? Yes. Do you know what is the reason for that? Because that ensures what is called as some administrative continuity. If something is pending in the house, some work is need to be done, it ensures that. So the other way that UPSC can also ask the question is that the term of the speaker is not coterminous with that of the term of what is called as the Lok Sabha. Okay, so that is also true, because anyways the speaker may not get elected in the first session or in the first day of sitting, because it may take some time before the speaker is elected. So this is also true. The speaker can be removed by a resolution passed by majority of the members present and voting. It is only by what is called as effective majority, not by simple majority. So what is which of the statements given above are correct? It is 1 and 2 only. All right. So how many questions are done? 150 questions are done. So we'll take a break today. So what I would suggest is go home and revise. It won't take much time. It will, I think, if you have already done well, if you have listened to the class, maximum 45 minutes to 1 hour. You can just quickly go through whatever mistakes, wherever that you have made a mistakes. Please listen, do not talk. Couple of minutes. So you listen to this, but if you want to come prepared for tomorrow's class, anyways, I'll complete the entire parliament. I'll complete the state legislature. I'll complete the judiciary as well. I'll complete the center-state relation. I'll complete the local bodies. That is, I think, till 300 questions I am planning, maybe a little more also. At least these topics, if you want to come prepared, you can come prepared, but otherwise you can come to the class also. If you are already prepared, you can just come sit and listen in the class. Please make note of the mistakes that you are making. So if you are coming and sitting in the class, it is not that you should not go without any learning. So it is something that you will have to make note so that you can avoid it, because if you have to do it by your own, which you can do it also, but it will going to take a lot of time. The only thing is, because of the experience, maybe I can tell you that these are the areas where you can make mistakes, which comes with experience. So therefore, sitting in the class, make full use of it. All right. All right. So with that, we'll wind up the class today. So tomorrow again we'll continue. If you want to revise, you please revise it. But if you want to be prepared, you see those topics and come. Okay. Thank you very much.